One.
May I please, your lordship? My lord, I am on visit, my lord. My lord.
Yes, sir.
I am submitting today to your lordship the orders passed with the earlier petition, my lord. That is the OJC number 6881 of 1998. Your lordship may kindly take this same on the record, my lord. My associate is there. My lord, before placing the order, I will state some facts, my lord. In the present writ petition, I am challenging the demand of demurrage amounting to 5 lakhs, some odd, my lord, on me. But the fact remains, my lord, I was appointed on basis of tender by the government as the clearing agent of the free care food supplied by the USA government in pursuance to the agreement between the President of India and the UNO. My lord, after I was appointed and an agreement was entered into with the government on 3/4/98, expecting that the first vessel will reach on 6/4, I filed an application to supply me poor laborers and other benefit by the Port Authority, by the Annexure 4, my lord. But fact remains, my lord, the first vessel reached the Paradip port on 7/4/98.
7/4/98.
That is SS Robert E. Lee, Boy 87.
That name is not necessary. 7/4/99 in the port.
My lord.
Paradip
port. Enter the berth, my lord.
1 second. And it disembarked the cargo.
My lord, yes. Free cargo, my lord, for feeding of the poor children of 11 lakhs of the state and lactating mother, poor lactating mother.
Lactating mother was traveling in the vessel?
No, my lord. This care feed was for them. The care feed was, free care feed was for them, my lord.
Problem is this, if somebody appears on online,
overlapping,
not be able to, what he says I cannot understand. What I say he will never understand. And what he will say you will never know. All these things happen. We are not at that advanced. We are at
my lord, earlier on that last date, I have undergone a major operation, my lord. So I am unable to go, my lord. That's why I am on VC, my lord. Sorry, my lord. You be excused. Thereafter, my lord, after the vessel reached, even the government.
On 7/4/1998, it reached Paradip port. I disembarked the cargo. Correct?
My lord, yes.
Then you answer.
It will be contradictory. Let me understand finish because we have to also refer to the documents.
Okay.
Then
on which date cargo was disembarked?
As per the documents submitted by the petitioner, my lord.
My lord,
page 37.
I the fact is necessary, my lord. After repeated request by myself and even the state government, because the cargo belongs to the state government, they did not supply the Paradip port and its management committee did not supply the poor laborers to clear the cargo nor cooperate with me. Then government having no way out on 1/5/98 issued a letter to me. If I cannot clear the cargo, then they will cancel my agency. So I filed the writ petition on 13/5/98. That is OJC number, my lord, 6881 of 1998. Your lordship kindly see the order sheet I have submitted to your lordship, my lord, through my associate, my lord.
1 second. Whose duty it was to disembark the cargo? Was it of the ship, the vessel itself, vessel owner, or of the owner of the cargo, hirer?
My lord, it is the duty of the owner of the cargo to clear it through any agent. Because here it is a state, my lord. The owner is the state, cargo owner is the state.
May I explain, my lord?
We are helpless, sir. No, your hearing will not help me.
May I clarify?
Yes, you are.
My lord, here tender was floated to the state of Odisha, my lord, for supply and distribution of care cargo, which was supposed to come by vessel, my lord.
Yeah.
The vessel landed in Paradip Port Trust, my lord. Thereafter, the petitioner was, by virtue of an agreement between the state of Odisha and the petitioner, he was appointed as a stevedoring agent to distribute, to take delivery of cargo and distribute in the state of Odisha, my lord.
So,
Yes.
petitioner was appointed as
Stevedore agent, my lord. Stevedoring agent, my lord.
stevedoring agent.
Yes.
Means what?
My lord, the stevedore is a work, my lord, which is done in the port areas, my lord. There are two categories of work, my lord. One ship docks in the dock in the port. The one category of workers are there who bring the cargo from ship to the shore.
Sure.
Yes. Then the second category of workers who take those cargoes from the shore to other places of the port.
Where they should be stored.
Yes, my lord, to the stack areas. So these are two different categories of the workers. Now the petitioner, my lord, was not a licensee stevedore under Paradip Port Trust. He filed an application, the writ application, which my learned senior is referring to. That by virtue of that writ application, an interim order was passed to induct him as a licensing stevedore under Paradip Port. Since
Only
he was
licensees alone can operate there.
yes, but only license. There are certain licensees who are operating. Now, after he was, my lord, there were resentment amongst other licensees, my lord, because he was not a licensee prior to that. So they did not cooperate with the present petitioner in providing workers to unload those cargoes, for which the present petitioner filed rectification, which my learned senior is saying, before this honorable court. This honorable court, by virtue of several orders, my lord, was pleased to direct the Paradip Port Trust to supply workers to the petitioner. Thereafter, to provide police protection, the state was directed to provide police protection to the petitioner to ensure that the cargoes are unloaded and distributed.
Why police protection?
Because there was a lot of hue and cry, because the present petitioner was not a listed worker of Paradip Port. So that by virtue of this order, now he got protection, police protection was provided by the state government, and because since the cargo was meant for the state government, and it's an agreement between the petitioner and the state government that he shall distribute the cargoes, receive the cargo from the ship and distribute. So pursuant to this honorable court's intervention, the cargoes were finally lifted and distributed. Our case is, my lord, we have a 45 days free period for storage. Beyond 45 period, demurrage charges are applicable. Now for normal cargoes, it's 3 days, and for special cargoes, it's 45 days. Since the present cargo relates to distribution of food for women and children.
Special or not?
It's special. So beyond 45 days,
they are liable to pay the
yes, we did not charge for 45 days. Beyond 45 days, since it overstayed in our shed, we incurred a lot of liabilities in terms of electricity and other charges. So demurrage charges were charged. 25 lakhs was charged to the petitioner. On the request of the present opposite partner one, the state government requested Paradip Port. Then since it's a special cargo, you waive the demurrage charges.
But you reduced it.
Yes, 80%. From 25 lakhs, it came to 5 lakhs. Our guideline says we can do it maximum to 80%. So we've done that 80%. So the remaining amount is 5 lakhs. Out of 5 lakhs, in the present writ application, the present petition, I believe, has deposited 2 lakhs as an interim order. So the entire issue now comes to...
Who should pay that?
My lord, entire issue now comes to 3 lakhs, my lord. Yes. Now, since the agreement is there, agreement is between the petitioner and the state government.
Petitioner
and the state government, yes. With regard to the cargo. I'll just place one line, madam. Page 23 of the writ application. It is his own document. Page 23. This is the letter dated 31/3/98. Annexure 3. Shall I place one?
Yes, place.
Well, this is a letter dated 31/3/98 of the Government of Odisha Women and Child Development Department. This is addressed to the petitioner, Swastik Singh.
Petitioner.
Yes, madam. Subject to undertaking of C and F. This is carrying and forwarding work of gift care communities at Paradip Port. I am directed to invite reference to a tender proposal submitted to this department on such and such to undertake the above work for the years and to say that your tender has been accepted being the lowest rate. Government has been pleased to appoint Swastik Stivra as clearing and forwarding agent for gift care communities at Paradip Port with effect from such and such. For the
Clearing and forwarding agent.
Yes.
What?
Those are the second category of worker which I say who take the commodities from the ship after it's unloaded from the ship towards the other portions of the port area to the sheds.
Ship will be how many kilometers away from the port?
It is on the dock only.
In the dock.
Yes,
small
yes,
ship.
Yes, there are two categories, as I said, but cargo handling workers. They are the employees of the port. They bring the cargo from the ship to the port. To the dock. Yes. And there are other workers who are called clearing and forwarding workers who take it thereafter from
harbor dock
to other shed areas.
Scheduled areas.
Yes, the present petitioner is not a CFNH agent. The second category of agent, he is not an agent. He got a provisional license for the first category of workers. He became a licensee for the first category to bring it from the ship to the dock, to below the ship.
Okay.
That is also as a provisional license. By
they come to
yes, ma'am. Yes.
Unnumbered, there are 3.
Yes, madam.
The cargo is to be attached to the districts
by the district storage and
transporting agent as per care advice duly authorized
by the collector DSW of the districts. Yes, madam.
This we are not concerned.
No, thereafter, daily lifting position of the stock should be intimated to the department by fax, and the stock should be cleared within 45 days free time limit, failing which demurrage charges at the port scale of rate will be paid by you to port authority. Demurrage charges for timely non-lifting of stock by the district storage and transporting agents will be paid by them.
No, one second. Why he should pay that under your rules? Who is liable to?
This is not rule, madam. This is, madam. Yes, for our rule, the importer.
Importer.
Yes, madam.
Means of the state.
Madam, importer who is getting the commodities.
I'm asking.
Yes, madam.
Here it is a state.
Here it's by virtue of the agreement between the state and the petitioner on behalf of the state.
No, agreement is between UNO and
no. Agreement is between state government and the petitioner.
State government and
yes, this is what I'm reading, madam. Yes. So, madam, thereafter, madam, the list. So what I mean to submit by this document is that, my lord, it was within the knowledge of the petitioner as well as the state government that beyond 45 days it will attract demurrage charges. That's what I'm saying. Trustee, this appointment order, last paragraph, is subject to entering into agreement with the government and the agent, the petitioner, will have to deposit 10 lakhs, which will refund it after making adjustment against the amount if payable. So this is a letter between the state government and the petitioner by virtue of which an agreement was entered into and they continued with the lifting. Thereafter, my lord, some hue and cry happened in Paradip Port for which there was delay and they could not lift it within 45 days. That's the case of the petitioner, for which they filed writ applications before this honorable court, and by virtue of this honorable court order, interim order was passed and they were provided protection.
Where is that order?
And this is what my senior gave now.
It was protection was given within 45 days or after 45 days?
That is now just I got the order. That is if
after 45 days. After 45 days. Your lordship may kindly see order dated 8/7/98, my lord. In the earlier writ petition.
After 45 days?
Yes, my lord.
Page number?
This is the compilation which my lord senior gave.
Compilation?
Yes.
When that compilation is
there is there.
Your lordship may kindly.
I am not good in admiralty law because I never conducted even one single case in admiralty jurisdiction. Yes.
The final order, my lord, regarding protection of police health. 8/7/98, my lord. Your lordship may kindly see orders number 7.
Order number 7.
Dated 8/7/98.
8/7/98. You're right.
In spite of earlier order passed by this honorable court in the present writ petition, since they did not allow, my lord, it is the case of the state My lord, your lordship, it is the case of the state that the state will pay the demurrage. My lord,
Where is that?
My lord, your lordship may kindly see the towards the last sentence of the first page, my lord, of that order. It is also stated that there was a diversion of 2 ships to other ports. It is further stated that because of delay in non-clearing demurrage is being charged, which would be ultimately be borne by the state. It is the case of the state, my lord.
It's the case of the state?
Yes, my lord, yes.
So you are not liable to.
My lord, my submission is that, my lord, then your lordship may kindly see the order, paragraph 3, my lord.
Second, I have to understand, na? But
My
poor
lord,
communication, very, very poor communication skill. Sorry to say that.
then paragraph 3, your lordship may kindly see of that order.
Whether you were party to this petition?
My lord, we had intervened. As it seems, my lord, we had
You were
intervened.
a party?
Yes, yes.
Whether you on your own you will be a
Yes.
party or they are,
Yes, yes.
I'm asking you.
Yes, my lord.
Were you a party?
Yes, my lord.
Were you a party when the order dated 8/7/1998 was passed?
Yes, Mr. Escapadi, he has
Well,
appeared. Yes.
And the stand of who appears for the state now?
Your Lordship other day directed to take instruction. Well, it was one period. So, I am told that the file is not traceable.
I do not know all that. I will not give time. 98 matter. People will laugh at us. They may pull down from the car. Nothing will happen to you because you will say judges are at fault. But I have to face the people if I go to the Cuttack market. So no time will be granted. It is your case that the state is liable to pay the demurrage.
And
That was the argument made before the highest court of the state.
the things, he has not solved a copy of the judgment,
Which judgment?
the annual
You-
judgment.
you
where
copy
it
of
is.
that.
Yes, no problem.
Give them. If that, therefore, I am asking, who is liable to pay? If there is an agreement between state and that person, there is no privity of contract so far as you are concerned.
No.
You cannot enforce some agreement between X, Y, Z.
No, madam.
You go against the state.
My lord,
What he says appears to be, regardless of the poverty of communication skill, what he says appears to be right. Law of agency by Willis, he says, as between two persons, that will be binding.
madam.
You are a third party.
My lord,
How can you proceed against him?
no, we are not proceeding. Lordship may kindly say demand has been raised both against the state as well as the petitioner.
Both we don't know.
Yes.
Both you are not justified.
Now, my lord, on the
You
request,
may
yes.
proceed against the state. State may recover it from him by a suit.
May I submit, my lord? Why the state comes into the picture is, my lord, because on their request, the cargoes were allowed to be lifted without payment of demurrage charges. Basing upon their request,
I must.
yes, my lord.
Suppose no demurrage charges are ever paid.
My lord.
What are you going to do? You are auctioning the cargo.
My lord, in that case, yes.
Isn't it?
Yes, my lord.
Whose cargo?
State's cargo.
State's cargo. Therefore, liability is of the state.
My lord, to that extent, Lordship is correct, my lord. But now, how am I prejudiced as a port authority, my lord? I have incurred those expenses, my lord.
Recover from there.
Who do I recover it from? The state. We have already made a request to the state.
They will
to make payment.
you take action.
No, in fact, I just make one more submission. After remission of 80% of the charges, my lord, demurrage charges, the state has again made a request to waive of the 20% also.
Therefore,
Yes.
So suppose,
My lord.
my view, that it is the state which is liable. Suppose if it were not liable, it would not have taken up the contention, waive the charges.
Lordship, and then, my lord, indicating that the state is liable, Lordship may give me liberty.
I will
Lordship
not-
may give me liberty, I'll proceed against them, my lord.
That, what is your prayer? Let us see what is the prayer.
The prayer is for the petitioner. He is seeking cancellation of that demand.
Then I have to cancel.
But
My
Lordship may give me liberty to state.
My lord, with your lordship's permission, my lord, your lordship may kindly see Annexure 13, page 41. The traffic of Paradip Port has written a letter to the government to pay the demurrage, my lord. Also on after my representation. Page 41.
Where is
Page 41, my lord. May I place, my lord?
1 second. Yes, face it.
Page 41.
Yes, face it.
Subject, dispatch, this is a letter to the Commissioner cum Secretary, Women and Child Welfare Department, Government of Orissa, Bhubaneswar. Subject, dispatch of care cargo. Please refer to this office letter of even number dated 18/12/98, wherein we had requested for payment of a sum of rupees 5,07,401 immediately towards outstanding demurrage charges after waiver of the Board of Trustees. We had fixed the date up to 31st/12/98 for said payment.
Prior to that, no, I am asking,
My lord.
how you are concerned with the postman? He's a courier. He brings the cargo and he lays it at the top of the button. That's all. And the goods belong to Mr. X. You have to proceed against X.
Only thing is, my lord, that has to be, my lord, read with the agreement between the state and the petitioner. If there, my lord, as far as I am concerned, Lord, I am now at loss because either the state,
because of ignorance of law.
Either the
Your
state is
client does
paying-
not know the law.
my lord, that.
Your client does not know the law. It is on the first principle.
My lord.
There is no privity of contract between you
My lord.
and the courier.
Yes.
There is no privity of
No.
contract. Therefore, whether he is liable under particular agreement or not, it is for the lookout of the state, not you.
My lord.
Therefore, I will reserve a liberty to you. After quashing this, you proceed against them.
But-
I will reserve a liberty to them to proceed against the petitioner if
Lordship.
contract provides
Grateful.
for that.
Grateful, my lord.
Right.
One thing Annexure 10. Annexure 10,
Annexure
page 30.
10.
Yes, page 34. Here, my lord, the Deputy Secretary to Government has requested the chairman, Paradip Porter,
To you.
last paragraph. It is very kind of the Post Trust to consider the humanitarian angle.
Where is the humanitarian end?
Yeah, because the care foods,
Yeah.
those foods are meant for the poor children and
What port should do that? You may be undertaking charity. It's your duty.
they have waived 80%.
That is the mistake. Their grace cannot be converted into duties.
Out of 5 lakhs, already the petitioner deposited 3 lakhs.
Let the state deposit.
And only 2 lakhs left. So my humble request before Lord, let the Paradip show its magnanimity and remit the remission
Which
of
law?
that 2 lakhs.
Which law compels the court to be
Not
magnanimous?
there is no law. No law.
Bible says it very well.
They have-
Bible is not law.
No, you're not. They have waived 80%.
So that's all right. That is their grace.
Only the remaining 2 lakhs is there.
Yeah.
Out of 5. That your lordship can. It's a year-old case.
That is because you held that money and with interest you have to pay.
State government cannot pay.
The multiplicity of litigations again will go.
Ultimately, what happened is, I do not understand why so many years have been taken for disposing of such a silly matter. Take note.
Your lordship can take note of it.
Yes.
Only.
Petitioner has structured his prayer as that. First one. The essential grievance of the petitioner will be seated. You can sit and answer. It is not primary school. We are all equal partners. I get offended when somebody sits, because otherwise a bar and the bench are 2 wheels of the chariot. What is that? 2 wheels of the chariot. One wheel this side and one wheel that side. Yeah. The essential grievance of the petitioner is as to the demand for demurrage charges for not lifting the cargo from harbor dock to the designated places for a period exceeding 45 days. First, counsel for the petitioner submits that there is no privity of contract between his client and the respondent port trust, which is a statutory authority under the
Major Port Trust Act.
Major Port Trust Act
1963.
First, he also submits that the cargo belongs to the OP state and the demurrages are payable for keeping the cargo beyond the specified time limit. Semicolon. If demurrage is not paid, ordinarily under the law of Admiralty by Ryden, the cargo is liable to be auctioned or forfeited, as the case may be. And in that event, the loser is the state and not the courier. First, lastly, he submits there is no privity of contract between the petitioner and the port trust, and therefore the arrangement between the state and the petitioner, whereunder arguably the liability is on the petitioner, cannot be enforced by the port trust, as has been observed by Chitti on contract. Chitti on contract. Okay. Next paragraph. Learned AGA, Mr. Lenka, appearing for the OP number 1.
Yes, sir.
Yes, OP number 1. And learned the panel counsel appearing for OP number 2, Port Trust, make submission in justification of the demand for payment of demurrage. And resist the petition, contending that it is the duty of the petitioner to pay the liability, discharge the liability, and therefore no relief can be accorded to him, more particularly in the light of the agreement between the state and the petitioner, which has the effect of expanding the liability on the petitioner in favor of the port trust as well. First, next paragraph. One more thing. Both the panel counsel and the AGA draw attention of the court to some record in support of their contention. Next slide. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. 1. It has been a long settled position in the law of contract that the contracts bind parties thereto, subject to all just exceptions, and therefore, in the absence of privity of contract, a person not a party to the contract cannot enforce an obligation resting on parties to contract. First, admittedly, the port trust is not a party to the contract entered into between the petitioner on the one side, the state and the state on the other. First off, no interest is created, no interest nor obligation is created in favor of the port trust to make it an exception to the doctrine of privity of contract. First up. Number two, learned counsel for the petitioner is right in drawing attention of the court to the order dated 8/7/1998 made in OJC number 688 of 1998 and MC number 8274 connected. MC number 8274 of 1998, wherein the state had contended, put it into inverts. It is further stated that because of delay in non-clearing, demurrage is being charged, which would ultimately be borne by the state. That's the invert complete. Therefore, there is enough material on the record of the earlier proceedings to which the state and the port trust were parties. First off, the stand taken by the state in judicial proceedings operates as estoppel in pias, and therefore petitioner cannot be saddled with the liability to pay demurrage charges. First off, the state also cannot take up a contention to the contrary, the battle lines having been drawn up between the parties herein in the earlier legal proceedings. First, in the above circumstances, the petition is allowed and writ of certiorari issues, crashing the demand, impugned demand.
And Annexure 7.
Annexure 7, dated 8/12/1998, at Annexure 7, was the petitioner. First off, it is made clear that the port trust may proceed against the state if it so chooses, in accordance with law. First off, it is also made clear that the state may proceed against the petitioner after discharging the demurrage liability as provided under section 72 of the Contract Act. Which section? Give the contract. Suit for contribution, or which is under 72, 71 or 72, where I pay for the liability of another in accordance with the Contract Act. Can anybody read out from Google section 71, 72 of the Contract Act?
Not one. 72 says, my lord, anyone who has received money or goods by mistake or under coercion must repay or return them.
Coercion. Yes. That is what Apex Court said.
It is the principle of quasi-contract.
That famous Mafathlal Industries versus Union of India. You can recover that money from these people. All right. In that connection, we have kept all contentions open. Yes, grateful.
My lord, my humble submission, my lord, in pursuance to order dated 2nd January 1999, I have deposited 2 lakhs, my lord. That may be refunded.
In the registry?
My lord, before the port authority, my lord. Before the port authority, my lord.
Authority.
That
you have to refund that money and recover that money from the state.
But this has to be verified again, because I have to take instruction. No, that's a submission.
Proceed against him.
That is a submission.
If the money is paid, you have to
pay. That say if paid, my lord. Yes.
The OP number 2 for trust is directed to refund any amount recovered from or deposited by the petitioner in terms of
order dated 7/1/99.
Interim order dated 7/1/1999 within 4 weeks.
She was 8 weeks.
Trust your thousands of crores.
Because Lordship also indicate if he has paid, because that's his contention. No, that has to be complied, my lord. If he has complied, that's what I'm saying.
No, you should say whether you have received or not.
That I have to again take instruction. 99 matrimonial.
There is also order that is complied with, my lord. Your lordship made a 1/3/1999 order. Put up this matter on 16/3/99. By the time the order dated directing deposit has been complied with.
If paid, will do. Yes, grateful, lord.
You can't proceed against some third party. One more point to add it. It is brought to the notice of court that the state itself had made a request to OP number 2 port trust to waive the demurrage liability, and such a waiver took place to the extent of 80%. 80%. First off, that itself shows that the state was liable and therefore it had sought for such a waiver, there being no contraindication in the record. That also make another notice.
Grateful.
Thank you.
Obliged, my lord.
Which is the best book on admiralty jurisdiction?
By Major Port Trust Act. Now it has become Major Port Authorities Act.
No, that's an act. Which is the standard English book?
I'll find it out.
Give that to our Bombay High Court Justice Kulkarni has written very wonderful books on admiralty jurisdiction. Yes. Yes.
Item 2?
Yes, my lord. Yes, sir.
The petitioner was appointed as the lecturer by the governing body, my lord, and accordingly she joined sometime in 2017.
10/10/2023 to 22/9/23.
Yes, ma'am.
As continuity in service.
And continued service. The notice to go.
Let them consider the representation with your
my notice to go.
Why?
Because the problem is representation, they will reject it and I'll have to.
No, they may reject it, but you have made the representation. You don't want to take any decision on that. Decision has to be taken by them. I will fix a time period.
Yes.
And in the light of normative basis, they will take a decision. Perfect. Right now.
A time period should be.
Yes, time period. Kindly be seated. Petitioner's short grievance is reflected in the prayer column, which has the following text. First one. Counsel for the petitioner draws attention of the court to the representation of his client dated 23/12/2023, wherein similar request is made to the principal of the college.
Principal comes secretary.
Principal, but you have said only principal.
No, that is
Page 32. College. First one. counsel submits that principal also happens to be an ex officio secretary of the institution, and therefore a decision has to be made by him on the subject representation. Basanto, in a type of way and in accordance with law. First of all, unless the court intervenes, comma, things do not move in the institutions like this, comma, he adds, first of all. Learned AG next paragraph. AGA appearing for the OP numbers 1, 2, and 3.
1 to 4.
1 to 4 also.
Yes.
President of the governing body.
He is the president of the AGM is the statutory president of the governing body under the Education Act.
State itself.
Yes, sir.
Appearing for the OPs, OPs submits that if a reasonable time is prescribed, comma, there would be no difficulty in considering the subject representation. First off, he caveats that all contentions of the parties be kept open so that the jurisdictional authority will take a meritorious decision. First off, with this proposal, counsel for the petitioner is agreeable. First of all, this is appreciable. Next paragraph in the Vocational. 8 weeks, contentions kept open to solicit. Now, no course. Now,
My lord, may I add one thing?
yes, sir.
That is the representation was made pursuant to the judgment passed by the Supreme Court under case Annexure 3.
It hardly needs to be mentioned.
Annexure 3.
The representation should be considered in the light of observations made by a coordinate bench of this court in WPC number 25405 of 2023 between Jagannasini Das
The petition, she was the petition deposition.
at first state disposed of on 11/9/2023. In the light of that, they will take that. Okay. Next.
Item 3.
Item 3, may I please? May I please, Your Lordship?
Item 3, my lords. I have been instructed to appear for the Indian Oil Corporation Limited. Let the copy of the writ petition be served. And
Give copy.
Yes, Your Lordship.
All right.
I'll serve in the course of the day, Your Lordship.
Copy of the petition along with all the documents should be served on the learned panel counsel appearing for
Indian Oil Corporation.
Indian Oil Corporation before sunset of the day. Okay. If copies are served, post this matter, week after next. Okay.
Item 4. In this case, my lord, the petitioner being a junior teacher discharging the duty of
You
headmaster
make
in
use
charge.
of either this mic or that mic. You are not using any one of them.
Yes, ma'am. Here, my lord, the petitioner being a junior teacher is discharging the duty of the headmaster in charge, whereas my lord, senior teacher is available in the said school, my lord. He is not taking over the charge from the petitioner, my lord. In this regard, he has filed one representation.
Who are you? You are the senior teacher,
I am the junior teacher, my lord.
junior teacher.
Yes, my lord.
Who is in charge of the principal post?
The present petitioner?
Petitioner is in charge of the,
Headmaster, my lord.
he is in charge headmaster.
Yes, ma'am.
You don't want to be in charge headmaster.
The senior teacher is available in the said school.
Yes, why if he does not want, I have seen reverse cases where I want to become chief minister or principal, prime minister, this thing. He says, I don't want.
Annexure 5 is pending.
Pending, how long it will, for all these things, people should come to court. When representations are made, why they are not being considered by the officers? Do they think that only if the court does things, they will consider?
There is no proof whether the representation filed or not.
No, anyway, now you have that now. I
And
am only asking, this court has become a representation court. Consider the representative. They will reject it. Then one more petition. Then contempt. First contempt, second contempt, third contempt. So it goes on, tamasha goes on like this. Where is the justice to the citizens? No, he is saying, I don't want to be principal. Senior is available. Please place him here. I want to work under him. Even that also they will not do. This is too much. Short grievance of the petitioner is reflected in the prayer column. First off, counsel for the petitioner draws attention of the court to the representation
Annex 5.
dated 14/7/2025, a copy whereof avails at Annexure 5, wherein he has requested for being relieved from the charge of principal post,
Headmaster, madam.
headmaster post, so that the senior most in the institution who is available can assume the charge. First off, learned counsel for the petitioner submits that there has been a bureaucratic culture in the state, and unless the writ court intervenes, all representations will be kept in cold storage. First off, day in and day out, this court has been treating such similar matters, and therefore there is a ring of truth in what the counsel for the petitioner is submitting, be that as it may. Next paragraph. Learned AGA Mr. Lenka, on request appearing for the OPs, submits that he would instruct the jurisdictional OP to look into the grievance of the petitioner within 2 weeks. Within 2 weeks. And inform result of consideration of the subject representation as well. First time. It has been consistent view of several high courts in the country that ordinarily the senior most person is asked to be in charge of the post of the kind when regular appointment is not being made. First, while considering the representation, this has to be kept in view. First off, an unwilling candidate cannot be asked to take the charge of some office on in-charge basis. First off, next one. In the above circumstances, petition is disposed of in the 6 weeks. 4 weeks. 4 weeks instead of to make it 4. Yes.
Okay,
No courts. Item 5.
The petitions are now, the boards of return, they make the representation before the OP number 1 to consideration, but till that no decision is taken by the OP number 1. So direct to the OP number 1 to take the decision.
Magnanimous to for sanctioning the service and financial benefits.
Lordship.
Personal. Petition prayer 2 reflects the grievance of petitioner. Personal. Petitioner has also made a representation dated
20 March 2025.
20 March 2025, a copy whereof avails at Annexure 8. Requesting sanctioning of service and financial benefits under granting aid GIA Order 1994 on par with similarly placed institutions, keeping in view several decisions of this court which have been affirmed by the apex court in subject SMBs.
If may I say,
Yes.
there are
Consider that.
11 petitioners. They have filed a single representation.
Yeah.
Teaching and non-teaching tasks are different.
Yes.
So while disclosing it may difficult, so let
They have made the representation. Individually, you consider and give them, ask them if I will make that. If you want any, I will ask them to give individual representation also.
that is one.
Next paragraph. Learned the counsel, Mr. AGA, Mr. Lenka submits that if petitioners give individual representations, ventilating their grievances, that would become handy for the answering OP to take the decision. And if one is given in a prescribed time limit, decision would be taken in accordance with law. First, with this proposal, counsel for the petitioner is also agreeable. Next paragraph. In the above circumstance, 8 weeks, solicit contentious capital.
Item 6.
May I please, Your Lordship? Lordship,
Yes, brother.
petitioner is illiterate and widow lady, Lordship. The husband of the petitioner was died in life.
Petitioner's deceased husband's name
Yes, Lordship.
as Adhikari Naik
Yes, Lordship.
instead of
Adhikanda
Adhikanda Naik.
Yes, Lordship.
Change of name.
Yes.
In what document?
In post-mortem report, Lordship.
In postmortem report.
Yes.
Why?
Lordship, in death certificate, in everywhere, that name is mentioned, the deceased was Adhikari Naik. But in the post-mortem report, doctor wrongly mentioned it was Adhikanda Naik, which is not correct, Lordship.
No, what is the consequence in postmortem report?
Accident.
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 Accident?
Yes, Lordship.
Oh, the tribunal may doubt it, etc.
Yes, Lordship.
Huh? You consider that.
They consider by the Your Lordship the concerned
You
IIC.
can lead evidence before the tribunal that this postmortem report,
Yes, Lordship.
this name, he is none other than this person only.
Yes, Lordship, I went to the police station, I went to the doctors, and I also gave them the representation, but no one is listening.
No, I am telling you,
Yes, Your Lordship.
during the course of evidence, you can lead evidence to show that
Yes,
the
Lordship.
person named in the postmortem report is the husband of the petitioner.
Lordship, I am showing it, Lordship.
But why it should be changed? Where is the cause of action?
Lordship, but no one is listening, Lordship, because of that the person was died because of the accident. So I am, Lordship, beneficiary of MB Act, Lordship, in 161 section, Lordship. Whenever
MB motor vehicle.
Lordship. So whenever I apply the money beneficiary benefit, Lordship, then I faced.
Short grievance of the petitioner is as to non-consideration of her request.
No, representation he has filed before the
Request.
Chief Minister.
Yes. If all others do not do, Chief Minister.
No, Your Lordship may let him file a representation before opposite party number 3 and 4.
Any Chief
And
Minister
they
is
are-
also answerable. He is not above law.
No. Yes, I
Once a representation is sent to the Queen, Queen will send it to the concerned department. The same is the procedure. The Chief Minister did not send it to the concerned officer, or at least he should have told. See, brother, madam, you have sent that representation to me. I have better job to do. Kindly make this representation to XY.
No.
That is good governance. Good governance means the highest executive authority should make all efforts to take the decision or send it to the authority who should take the decision. He cannot say, I am not the concerned authority. That is not good governance. There is a famous book by Arun Shauri, The Governance. Just see that. It's one of the best books. Shauri is a great author.
Yes, journalist. So,
You give one more representation to this.
before OP 3 and 4.
Yes.
And that place representation
The
is
short grievance, let me recall that. The short grievance of the petitioner
and
is,
IIC.
has to, her husband's name being wrongly mentioned in the postmortem report, comma, he having died in a vehicular accident. First time. Husband's name is
Adhikari Naik.
Adhikari Naik.
Yes, Lordship.
Adhikari Naik. Whereas his name is wrongly, this name is wrongly mentioned as
Adhikanda Naik. Adhikanda.
Adhikanda Naik. Adhikari Naik instead of Adhikanda. Adhikanda.
Yes, Lord.
Naik in the prayer column.
Adi Khanda.
Adhikanda. In the prayer column. Counsel for the petitioner vehemently argues that wrong name being mentioned in the postmortem report may create some difficulty in prosecuting the claim for compensation under the provisions of the Motor Vehicles Act. And therefore, A representation is made to the Chief Minister. See, you should have made representation to the President of India.
No, Lord Sir, I sent to representation to every person, Lord Sir.
Seeking rectification of the name in the post-mortem report.
Lord Sir, medical officer, police station go.
Council also submits that similar representations were made to the medical officer and to the jurisdictional police, semicolon. They having not taken any decision, left with no option, he has made the representation to the Chief Minister, who happens to be the highest executive authority of the state. First, next paragraph. Learned AGA, Mr. Lenka, on request appearing for the office, submits that if the petitioner makes an appropriate representation supported by evidentiary material to the OP number 3
And 4.
and why for
Police was there.
why police? The post-mortem report is prepared by the medical officer.
Medical officer.
Yeah.
And the police on the request of police. Because after the incident was happened, the police brought the dead body to the medical.
But the decision has to be taken by the medical officer. For this medico-legal jurisprudence, it says post-mortem report is prepared by the medical officer.
Yes, that is there.
Yeah. Therefore, he has to take the decision. OP number 3.
Police has made the inquest report.
The same would be considered within the shortest possible time, with the participation of OP number 4 police as well. First. Next paragraph. In the above circumstances, petition is disposed of. In the above circumstances and with the above observations, petition is disposed of. Time for compliance, 2 weeks. 2 weeks. Great prayer. Item 7. This medical legal jurisprudence says how post-mortem report is prepared and who prepares the post-mortem report. There are some judgments also. Yes. Item 7.
The adult school teachers, my lord. Their
Salary from 1/1/2016 to 39/2017.
Revision period.
Differential pay.
Differential pay.
Because of revision.
Yes, ma'am. That is covered by in paragraph 8, page 7, page 5. Paragraph 8 has given 2 judgments. And the same matter has been decided.
Dipti Ray.
In Dipti Ray.
Dipti Ray.
Yes, ma'am.
We made similar orders, no?
Yes.
Do you have one copy? Where we said to follow this?
That has been page
Para 8.
in synopsis and para 8 also mentioned.
Do you remember? Got it. Yes, right. Petitioner's short grievance is reflected in the prayer column, which reads as ever. Petitioner has also made a representation dated.
Copy is not there.
No representation is made.
Yes, no representation.
Counsel for the petitioner submits that in the light of decision of this court in Dipti Ray, para 8 of the Sunnah, there it is there, just come on. The relief in terms of prayer column ought to have been accorded to his client by the OP number to his clients.
OP number 2 and 3, Director and District Education Officer.
OP numbers 2 and 3 in the light of the said decision. First of. Next paragraph. Learned AGA Mr. Lenka, appearing for the OPs, resists the petition, contending that there are multiple petitioners, and no representation is also made, and therefore no relief can be granted as sought for. Having so stated, he suggests to the petitioners to make an appropriate representation in the light of the decision in Srimati Deepti Ray versus State of Orissa 2004 2 OLR 718 and Dr. Yudhishthir Patnaik versus State of Orissa 2008 1 OLR 890. First, if such, he also assures that if one be made, the same shall be considered in a time-bound manner and in accordance with law. First, next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioners to make their individual representation to OP number 3 and 4 and
2 and 3, my lord.
2 and 3. 7. If made, OP number, the said OP shall take a decision thereon and inform result of such consideration to the OP's petitioners individually within an outer limit of 8 weeks. First term. It hardly needs to be stated that the decision has to be taken in the light of Deepti and Yudhishthir Supra. All contention kept open to solicit, etc. Next. Yes. Item 9.
This is regarding the RSCP minor, benefit of the RSCP. That is your lordship's order.
Notice has been issued. Disposed of? No.
Fresh representation will be filed.
Is the sentence to be completed, not summons. If sentence is incomplete in the judgment, okay? That's why you put where the English technology so that we'll know that. As summons of yesterday, I have completed it.
The RSCP to the petitioner's husband, my lord. That in the meantime, the petitioner.
The same similar order. Yes. Item 10.
Item 10 regarding to RSCP, my lord. Similar matter also.
RSCP.
Yes, my lord.
Take that also same. That third paragraph sentence to be completed. Yes.
This case, I am challenging the rejection order by the annexer section dated 13/8/2025, my lord. Page 81. Though they have given some benefits to a number of teachers.
Take notice.
Yes, sir.
Won't they accept notice? Any private party?
No. Under government.
Matter lies in error of compass. Post it
1 to 3.
after 8 weeks. Okay. Next. Item 12.
Madam Pleasure.
Yes.
The petition is a primary school assistant teacher lordship. The challenge is made on Annexure 3, page 15, the memorandum charges given to the petitioner for so cause, so filing the statement of defense lordship, and that has been issued on 25/8/2025.
6/8/25.
My lord, time bound was within 30 days it should be filed.
Receipt of this memorandum.
My lords. Then on 25/8/2025, I have repented to the authorities for supply for relevant documents, Your Lordship. And till yet, that has not been supplied by the authorities, so that I am unable to file the
Where is your
statement.
representation?
That is Annexure 4, Your Lordship, page 20.
What documents you are sought for?
Page 22, Your Lordship, the Annexure 1 to the representation, the documents, 4 documents I have sought for.
What is the charge?
Charges, Your Lordship, for that is at page 16, Your Lordship. Basically, the production of false documents. I have joined in Shiksha Sahayak since 2011, and I have been regularized since 2017, Your Lordship. And now when the promotion is
You put copies of those documents. That's all. Kashinath Dikshita versus
Yes.
so and so. Which is that judgment?
Yes. I have your lordship.
You have mentioned that?
Yes.
Do that. Short grievance
Six,
petitioner
three Supreme Court.
is as to non-furnishing of the documents enlisted in the charge memo dated 6/8/2025. First, counsel for the petitioner submits that when charges are leveled against an employee and show cause notice is issued, all documents on which charge is sought to be proved should be served in copies to the delinquent. First off, this view gains support from the decision of Apex Court in Kashinath Dikshita versus so and so. Do that. Next paragraph. Mr. Mohanty, appearing for the OPs, very fairly submits that he would instruct OP number 3.
OP number 3.
OP number 3 to furnish the copies of documents as have been enlisted by the petitioner in his representation dated
25/8/25.
25/8/2025.
BO.
Well, this may be 4. BO.
Yes, lordship. BO.
44. At annexure
For your lordship.
4 series.
My lordship.
At annexure 4 series. First one. This is appreciation. These documents, the copies of these documents should be furnished within a period of 2 weeks. And till then, no precipitatory action shall be taken against the petition. First one. Ordered accordingly, WP is disposed of.
Oblige, lordship.
Item 13.
In the block down pension matter, the extra copy will be served and OP4 is the private respondent notice to.
Merchant notice. Only 3. 1 One TFS for 1 and 2. Third is
Third notice to.
Fourth is to.
where is 4? Only 3. Third. Emergent notice to OP3. Yes.
Item 14.
Yes.
Lordship, the petitioners are working as a physical education instructor. They have made the representation for regulation of the service. In the identical issue, Lordship pass the order. I have annexed the Annex 5. Annex 5 those. In the case of Jago versus Union of India.
Any representation you have given?
Annex 4, Lordship.
The short
They are relying upon your lordship judgment, keeping
of
with
that-
that
Jago.
Only 2 lines has to be corrected. Where the year of service is here the 12 years, but it has to be 8 years. And the next page, Lordship.
No, I will do it this way. Wait. The short grievance of the petitioner is as to non-consideration of his representation dated 7/4/2025, a copy whereof lies at annexure 4, wherein he has sought for regularization. They have sought for regularization of their services as physical education instructors. First off, counsel for the petitioner submits that the case of the petitioner is squarely covered by decision, a division bench decision of this court in which is that the edition of this court in WPC 23048 of 2025 between Jagannath Das versus State and others disposed of on 21/8/2025, rendered in the light of Apex Court decision in Jago versus UOI 2024 INSC 1034. First time. Since the representation is kept in the limbo, comma, he calls interference or calls for the indulgence of this court. First. Next. Learned AGA appearing for the OPs very fairly submits that the OP number one shall take a call on the subject representation if a reasonable period is prescribed and all contentions are kept open. First up, with this proposal, counsel for the petitioner is agreed. Next, in the above circumstances, 8 weeks. Open to solicit information, etc., etc. Now, no cause. Okay. Item 15.
15. May I please your lordships?
Yeah.
Lordship, this petition has been filed challenging the inaction of the OP number 3 for considering the appointment of the petitioner in the rehabilitation.
Representation. Your prayer itself is that.
Yes, my
Who
lord.
are you? What is that representation?
My lords, the representation is at page 10, my lords, the application which I have submitted, and thereafter, my lords, at page 13, my lords, the headmaster of the particular school, which the petitioner father was in service, my lords, they have also written to the DEO, the OP number 3, for considering of appointment of the petitioner in the as per the RS scheme, my lords.
This is for your appointment.
My lords, appointment under the RS scheme, my lords.
Huh? Under the
Under the rehabilitation scheme, my lords.
scheme is 4th April 25.
Because 4th April 2025, because they have come up
90 rules and 2020 rules.
because there's a
They
clarification.
came, so far the amendment is concerned, it is effect from 4/4/2025. In
4/25 the notification.
Exactly. Thereafter, my lord, that Jita law came into picture.
Correct.
So far, this present petitioner is concerned under the Rule 9(6), the amendment and clause B. It is at page 11 for a moment.
Yes, my lords.
Rule
Page 11.
Page.
right up. Petitioner's application for engagement under the Rehabilitation Assistant Rules 2020 having not been decided, comma, this writ petition has been filed. First one. Learned counsel appearing for the petitioner vehemently submits that the application for appointment on compassionate ground has to be decided on a war footing so that the distress in the family of the deceased breadwinner is mitigated. First of all. Next paragraph. Learned AGA appearing for the OPs very fairly submits that he would instruct the OP number
3, my lords.
3.
3. District Education Officer.
3. So look into the grievance of the petitioner in a time-bound way and in accordance with law if a reasonable period is granted. First time. This is fair. Next paragraph. In the above circumstances, 8 weeks, open to solicit, now no course.
Much obliged, my lords.
Item 16.
May I please?
Yes, brother.
My lord, the petitioner has challenged the illegal and unfair action of the opposite party in rejecting the candidature of the petitioner, my lord. The fact of the case is, my lord, the petitioner has...
Consider your representation for allotment of the plot.
Yes, not the representation, my lord.
Application.
Application for allotment.
Who should take the decision?
The Secretary Cuttack Development Authority.
Secretary Cuttack Development Authority.
My lord,
Any
the case is...
counsel it has got.
My lord, there are panel of counsel, my learned Mr. Dayanand Mahapatra,
Yes.
who is usually appearing.
My lord, the case is that...
All right, we are issuing emergent notice now.
Yes, my lord.
All right. Okay. You want to argue. Your client is here. Argue. Say a few words.
My lord, the case of the petitioner is that the petitioner submitted all the necessary documents
Along with the application.
with the
And
application.
he also you have paid.
Yes, my lord. The cause of action arose on 11/9/2025, my lord, when the date of the lottery was on 11/9/2025, but on the same date they have prepared a list showing that some of the candidates were rejected on the ground that the ITR oblique income certificate of R&DM not submitted.
You had submitted that?
Yes, my lord. And my lord, kindly have a glance to Annexure 1, my lord, page 20, the application, page 15, my lord.
Will issue notice?
Yes, my lord.
Issue emergent notice.
My lord,
Reasonable within 4 weeks. Yes.
my lord, I have filed a IA application for stay of the further proceeding, my lord, because if the allotment will be prepared, my lord, the case might be infructuous, my lord.
We'll say allotment shall be subject to outcome of the petition.
Yes, my lord.
Any allotment in terms of subject lottery shall be subject to the outcome of the petition and list pendants.
Obligation.
By way of list pendants.
Item 17.
May I please, your lordship?
Yeah.
May I please, your lordship? I mean, this is my lordship.
Yes. Yes.
I am audible, your lordship? I am audible?
Yes, audible and visible also.
Your lordship, my application, petitioner filed the application on dated 21/10/2024 before the opposite party number 2 for substitution application. For Anand
Substitution
application. He is the successor of the deceased Anand Construction, your lordship.
You take notice.
Your lordship. But during the pendency, your lordship, so many amounts is pending before the opposite party number 2. And the interim direction may be given to release my pending so that I can pay the labor payment and other statutory dues, your lordship.
Returnable within 3 weeks. Emergent notice returnable within 3 weeks. Let us see. No interim order. Okay.
Obliged, your lordship.
Item 18.
Passover. What is that? 18 prayer just so that Constitution.
Will file counter.
Issue emergent notice. Mr. Behura, Learned AGA, accepts notice for all OPs. First matter lies in that managing committee of Sayed Seminary School, that the separate notice.
Yes, madam.
Emergent notice to for OP4. Post immediately after service since matter lies in a narrow compass. Yes, next.
Item 19.
Yeah, please. Well, petitioner was engaged co-com helper. By petitioner was engaged with the co-com helper.
Co-com helper.
Yes, my lord. By this OP number 6. By the OP number 6. But all of a sudden she has been debarred from duty to perform her duties on the basis of the incorrect date of birth. Now she has taken count. She has crossed the age limit of 60 years. So they didn't allow to perform her duties.
Retirement age is not applicable.
No, the petitioner now is age 53. Because on the basis of the incorrect date of birth mentioned in the Aadhaar card, they have taken such ground. She has crossed the age limit.
The date mentioned in the Aadhaar card is
Aadhaar card, incorrect date of birth. But no Aadhaar card I have. Honestly, also kindly see the.
No, which is your correct date?
22/5/23.
Where is that?
Your lordship kindly see the page 9, the school living certificate and voter card. Your lordship kindly see page 10, voter card. Voter card.
Voter ID.
Voter ID.
What is your educational qualification?
Educational qualification standard 5th.
Standard. But you only give your date of birth in the Aadhaar card.
Only Aadhaar card 22/5/25 now correct date of birth I have given. Aadhaar card.
No, 1973, 22/5/1973. There is a transfer certificate.
Yes.
Take notice, Mr. Emergent notice. First off, matter lies in a narrow compass and therefore post it after 4 weeks. Can I come back after 3-4 minutes?
Yes, sir.
Emergency notice in 8 weeks. Okay.
Any appointment shall be subject to the date.
Any appointment shall be subject to respondents. Okay. Item 20.
Listeners. In this case, my lord, the petitioner has been subjected to successive order of transfer. Repetition WPC 7018 of 25 is pending. Yesterday it was there in the list of my lord. It could not reach because of the procedural time. So this matter along with that. Yes, this case I have filed because I have challenged the order of transfer. They put me under suspension and initial dismissal proceeding. This is the challenge here.
Let us issue emergency notice. 88 to accept notice for OPs. All accept notice for OPs. All this matter along with WP number
7018 of 25.
Yeah.
May pay for an listing of this case because now they're taking coercive action.
Let us see.
Because I could not join because I challenge it. Now action. Can then kindly fix a date at least so that I can. Yesterday it was there in the list of my lord. I don't know when it has been listed. 26/7.
Yes.
Item 21.
May I please, your lordship?
Yeah.
My lord, non-consideration of representation. Non-consideration of the representation of the petitioner dated 12/8/2025 by the OP number 3, my lord.
Permitted to join.
OP number 3, yes. Dismissal was there.
They are permitting you to work there.
Yes, my lord.
Why?
I have represented in all the aspects.
Why they are not permitting you? Why they are permitting others and why not you? There must be some reason.
My lord.
He has been dismissed from service.
My lord. Dismissed from service.
Then how can you be?
I have detailed in the representation. They may consider, my lord, I think.
No, if you are dismissed,
my lord,
what ground you are dismissed?
My lord, page 84, my lord, I have given liberty from this honorable court to
re-agitate the
writ appeals, and now I have filed representation before the OP number 3. The last page, my lord, 84. All the
agitate before other bodies, not before this court. You have withdrawn the petition also.
Oh, withdraw the writ petition, writ appeals, my lord, and approach the OP number 3 in details to consider my case.
No, why you were dismissed from service? What is the ground? What was
Sexual harassment in workplace.
And it is proved.
Yes.
Proved. Then how to retain you as a lecturer? What will happen to the girl children then?
He has represented all the.
Correct. Where is the question of?
Yes, my lord. Yes, my lord.
There is nothing.
I have detailed in my defense.
Your inquiry was held against you. You means against your client.
Yes, my lord.
Inquiry was held. Found guilty. Yes. No appeal is filed against it. No. You have not filed appeal.
As per instruction, I have not filed, but I have only represented my case before the OP3.
So we have represented.
OP3, my lord.
OP number 3.
My lord.
Who passed the dismissal order?
Governing body.
Governing body, my lord.
What?
My lord.
Of Vice College.
My lord.
For Ghana Karya which your client has done. Whether appeal lies to whom?
Well, it's tribunal.
No, go to the tribunal.
Institution.
Minority.
It's a minority.
Minority institution. So no tribunal. Where he has to go? So
Yes.
no told.
I put. Because it is a minority aided institution.
Aided institution.
Minority aided institution. Section 2 is a bar.
There is a bar.
Education
No,
Act
civil
Section
code.
2 is a bar.
No. Yes. writ petition.
It is an aided institution, but minority aided institution.
48 ଭିତରେ ଆପଣଙ୍କର
Christ College.
Christ College is a minority aided institution.
Minority aided institution.
Aided institution receiving aid from the state government.
Well, but you have withdrawn your earlier appeal, writ appeal.
My lord, and representation was filed after
Writ appeal has withdrawn.
my lord. After withdrawal of writ appeal, then I have filed the representation before the officer to consider my case with all contention was there.
Petitioner, having been dismissed from service on the culpable conduct of sexual harassment at workplace, was before the court earlier in WP number what is that WP number?
WA number, my lord.
How directly WA? There must
No, yes, my lord. WBC was there.
What brother, you do not come with preparation at once. But you will come. What was before the writ court? First up. Later, matter was carried in Writs Appeal numbers 19 of 2024 and 78 of 2024, which petitioner withdrew.
It is arising out of WPC 3150 of 2020.
WPC 3150 of 2020. First up. Later, matter was carried in writ appeal numbers so and so and. First up. The said writ appeals came to be withdrawn with liberty to agitate the cause elsewhere in accordance with law, keeping open all contentions of parties. First, kindly be seated. Counsel for the petitioner submits that, next paragraph, in terms of liberty reserved by the division bench, he has already made a representation to whom you have made, brother?
OP3, my lord.
OP number 3.
Agenda next one.
And therefore he be directed to take a call thereon in accordance with law and within a reasonable period. First, learned EGA opposes the petition contending that the writ petition having been dismissed and writ appeals also having been disposed of, affirming the order of the learned single judge, what purpose would be served by directing consideration of petitioner presentation is not forthcoming. First up, having so stated, no, he agrees to instruct OP number
3, my lord.
no. It is governing body which are dismissed you. But representation is given to whom now?
OP3, my lord.
3.
My lord, governing body. 2. OP2. OP2
But you are dismissed by the governing body himself.
OP2 to consider, my lord. Director to.
But representation is addressed to OP number 3.
Yes, my lord. I will file the fresh representation.
OP number 2 to consider if a fresh representation is given, in accordance with law. First off. he caveats that all contention should be kept open, since already the petitioner had lost the legal battle, single judge and the division bench as well. First now, next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate representation to the jurisdictional authority, and if one is made, the same shall be considered by the within 8 weeks. Within 8 weeks. Full stop. In that connection, all contentions are kept open. Item 22.
The petition is playing for birth certificate to be issued by the OP number 3, sub-collector. My lord, on the condition, the non-availability certificate be issued by the registered birth and death of the Deccanal municipality on production of either of the document, HSC certificate or board certificate or any means proof showing the date of birth. So the sub-collector is in, my lord, the requirement of the non-availability certificate to be issued by the municipality. So municipality is saying that because my date of birth is prior to 69, prior to coming into force of the registration of birth and death. So sub-collector is the appropriate authority. So here is a condition imposed by the sub-collector that a non-availability certificate be produced by you to be issued from the concerned municipality. So that now the municipality is, my lord, Annexure 8, page 37, admitted that
we have no such certificate.
Yes. So only they will say, and they will only issue the NAC, non-availability certificate. Then the sub-collector will process the file. Only this one. So without, my lord, any remark by the to be issued by the registered birth handler, only saying that the school admission records HS certificate, higher secondary certificate. So I have my lord projects the HS certificate under
now what he says?
He says, page 37, further as per Orissa revised birth and death guideline, non-available certificate may be issued for birth certificate basing on the records like school admission record, HA certificate or higher secondary certificate as a proof of date of birth. So from these three requirements, I am possessing Annexure 2, page 16. The mark sheet issued by the concerned headmaster.
What to issue the caste certificate is saying now?
Well,
your prayer is for issuance of the caste certificate.
Caste certificate will be issued by the sub-collector.
Correct.
So sub-collector is saying that NAC be produced by you to be issued from the concerned municipality, because I was born in district headquarters hospital. So as I was born in the district headquarters hospital, so by that time the municipality was controlling the area whereunder I. So the sub-collector, that is why he is saying that the NAC is required, non-availability certificate from the concerned municipality.
But they have given some certificate.
Yes, my lord. Only I have given the Annexure 2, page 16, the certificate. So sub-collector is not accepting, only saying that.
What it says, this certificate, this is mark sheet.
Mark sheet.
You mean to say, you take notice, brother?
Simple prayer.
No, a prayer is simple. Let them say something.
Layer number 2 seeks direction to opposite party number 5 to search and trace the petitioner's birth record on 26/7/2069.
You take notice, let us see.
Yes.
Yes. Issue emergent notice. AG accepts notice for 1, 2, 3, 5 and 5. Speed post to OP4. First of it. Emergent notice to OP4 by speed post. Okay. Vote immediately after service.
Item 23.
Item 23, madam. Petition is the MSME registered unit. MSME registered unit. The Rayagada district. The district OP number 6 invited
But it is your right that you selected.
There is.
What is your right that you should be selected?
I am the MSME registered unit. They have selected for 3 blocks. I have applied for 10 blocks. I have a capacity much more than 70,000 production of dress materials, supply of dress materials.
But if they do not want?
They are procuring from the outsiders, local markets. That is violation of the guideline.
Which is that guideline?
Guideline is Annex 4, my lord.
Annex 4?
My lord.
What it says?
Odia version, my lord.
All right, you translate it. You read it loudly and translate so that people also will see whether you are telling the correct thing or not.
Annex 5 is the English version of the
Annex 5.
The terms and government and the supply of school.
The supply the material and then given with the wearing with they may provide more than one sample. You take notice, Mr. Behra, and file a.
My lords, the prayer is to select him.
They have selected.
He can be considered along with others.
Only for 3. For 7, they have not selected you. How can you compel that you should select you?
I am loan of rupees 10 lakhs from the bank.
So what they should.
So no, after this is the Annex of 5, and I have a glance at EOE invited by 8/7 to
Where is your representation? Show me how you structured it.
What representations? My lord, 7 series. My lord, that is also Odia version.
All you have put Arrear so that I do not understand. If judge understands, he will pass some adverse order. If he does not understand, he will not be able to pass order, or he will pass wrong order, which we can put in writ appeal. Who should consider the representation?
OP number 6, man.
You just consider the representations which are in Arrear. You give reply also in Arrear.
No, they are now procuring the dress materials from the local
representation. That itself, whether I should reject it, I'm just thinking. But anyway, very innocuous prayer. Petitioners' grievance is reflected in the prayer, which reads as personal. Before making this prayer in rich jurisdiction, petitioner has made a slew of representations in colloquial language, copies whereof avail at Annexure.
Another 7 series, man.
7 series? Annexure 7 series. First up. Next paragraph. Counsel for the petitioner submits that his client being MSME, he is entitled to priority in allotment of contract to the exclusion of others. Although 3 units have been allotted, 7 have been allotted to private entities, which is impermissible in terms of extant circular. Circular dated?
Guidelines also, but is Annex 4.
Extant guideline dated?
My lords, there are 38 MSME registered and 168 SSG groups are there under this.
He cannot claim that he only should be granted.
Exactly.
You can give that reply to them.
Yes.
At Annexure?
Annex 4.
First up. Counsel submits that his client would be satisfied if a direction is given to OP number
6, madam.
OP number 6 to take a call on the subject representation in accordance with law and within a reasonable time. First off, learned AGA Mr. Behura, having opposed the petition, now agrees to instruct OP number 5 to look into the grievance of the petitioner as has been aired in the subject representation within a reasonable time, provided that all contentions are kept open. First off, with this proposal, counsel for the petitioner is agreeable. Next, the worst circumstances, petition is called off 8 weeks. Open to solicit, now no question. Item 24.
May I please?
Yes, sir.
The petitioner is a trained graduate teacher of an aided high school.
He's from 52,000 to 47,000.
My pay has been reduced without giving any notice. I have brought a judgment of the Honorable Apex Court. Your Lordship may kindly see that.
How many years of service you have got it?
My Lord, my present age is 53 years.
So another
7 years left. 7 years left. And no notice, no so-cause, nothing.
Why they have reduced?
But no reasons have been assigned.
No, there must be some order.
But Your Lordship may kindly turn to Annexure 10, that is the impugned order at page 32. My Lord, while fixing my pay under the ORSP rules 2017, my Lord, they have reduced my gross pay. My Lord, initially when I was appointed, my Lord, I was appointed in an unaided school. The school was notified to receive block grant from the state government with effect from 1/1/2014. As per the granting aid order of 2017, my Lord, the principle has been evolved that for every 3 years from the date of receipt of granting aid, one notional increment will be granted. And accordingly, since I got the with effect from 1/1/2014, I got notional increment in 2017, 2020 and 2023. Now, my Lord, that 2 increments have been reduced and accordingly my gross pay has been reduced. And reduction of pay is also a punishment within the meaning of Rule 20 of the 1974 rules. If they
misconduct is proved.
Yes, misconduct.
If there is no misconduct, then it is not a punishment at all.
But if there is no misconduct, it is not a punishment. But it is not a punishment. Here, my Lord,
given etc.
Here, my Lord, there is no, absolutely there is no justification to reduce my pay. That is their own circular or own granted aid order. Your Lordship may kindly see I have annexed that.
You take emergent notice?
Yes. And that order will be kept in abeyance. Because otherwise, my Lord, no notice, nothing, and Your Lordship may kindly see the judgment of the Honorable Apex Court, para 19 to 21, 3 judges bench.
What it says?
My Lord, para 19 to 21.
No, what it says,
it says that about the employees, my Lord, if an order is passed affecting the employee financially, my Lord,
he should be heard in the matter.
He should be heard in the matter, and at least a fair hearing is necessary.
They have not given any opportunity.
No, Your Lordship may kindly see para 14. I have categorically averred no notice, unilaterally that order was passed. Para 14 of the petition.
Go to the question. AGA, Mr. Behura accepts notice for the OPs. First up, the counsel for the petitioner submits that an application in IA number so supported by affidavit is moved, seeking interim protection in Admitted. The salary has been reduced from rupees 50.
That is 52,627 to 47,600.
Stands any opportunity of hearing. This is contrary to Apex Court decision in
that state of Punjab and others versus senior vocational staff.
My Lords, the order is of May 2020.
He has got service. I saw that.
My lord.
But for these days, the months you need not pay. But from this the month onwards, you
Yes.
pay it. For 5 months, you will not be paying at all.
My lord, it's for hearing, we will find out.
7 years service he has got. In the event, if he takes money,
Your lordship will clarify that.
I'll clarify. Yes. There is force in this submission. Next correct. In the opposite circumstance, application having been favored, impugned order whereby salary is reduced
In respect of the petitioner.
in respect of the petitioner is hereby stayed. Subject to outcome of the petition.
Yes.
Petition. First off, the contention of learned AGA that if petitioner fails in the writ petition, it becomes very difficult to recover the excess amount, and therefore some condition being imposed is fair. First off. However, that contingency can be looked after, can be taken care of, since petitioner has got still 7 years of service to lay down the case on attaining age of superannuation. First. Next.
Lord, I will be pardoned.
Yes.
Lord, so far as yesterday's hearing is concerned,
Yeah.
Lord, I have noted down my points.
But judgment is ready.
Yes.
I wanted to pronounce it today.
Yes, yes.
Anyway.
Your Lordship may kindly go through it.
Not.
I have only indicated my points.
Correct. Item 25.
25 covered by the Loknath Behra judgment. I have given the corrected copy. Other two is same.
Section 0 completed. Section 0 completed. Yes. 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 Item 26.
In this case, the petitioners challenge the transfer order under Annex 11 on the ground that the petitioner is the husband working in the same school, but as per the government notification, the wife transferred from another block to this school and working joined in this school on 1st September 2025. And the transfer order was passed on 6th 10/12/25, transferring the husband petitioner from this school to distance of 50 miles. Violating the guidelines, my lord. Your lordship may kindly have a chance to.
Which guideline is violated? Which guideline is violated? Is that
The government of Odisha.
which is that guideline? Point out that particular guideline.
Yes,
is
ma'am.
violated.
The education and youth service department has decided that in order to avoid the dissolution of work in the teaching institution, whenever transfer of any individual teacher from the one place to another is contemplated, the transfer question should invariably
Spousal facility.
Yes, my lord. Yes, my lord.
Issue emergent notice. Have you moved application?
Yes, my lord. Honorable Annex, sir.
In IA number 18208 of 2020, supported by affidavit is seeking stay of the issued order of transfer on the Spousal.
Yes, filed a representation to the.
I have filed, but I have filed this first passing of that.
So what we will say is, when your representation is considered, you will not be disturbed.
Yes.
All right. Counsel for the petitioner submits that against the transfer order in question, his client has already made a representation. Yes.
Lord, that is addressed to the
8/10/25.
that is addressed to the B block education officer.
To the director of education.
District education officer.
I have given the
To him also.
to the director. I already given manner.
Where is that?
Page 40,
Copy for it.
page 41, running page 43. I given the director school and master.
Recall that. Short grievance of the petitioner is the transfer order dated 6/10/2025, whereby he has been shifted to a place more than 100 kilometers away from the present. 145 kilometers away from the present place. First, counsel for the petitioner presses into service the office memorandum dated 6/8/1986, which provides for protection on spousal grounds. First, he contends that though representation is given in the light of decision of the Varadhara versus State of Karnataka, no decision has been taken on the same as yet. Have you been relieved?
No.
And that anytime he is going to be relieved from the present school or joining the other school. First. Next one. Learned AGA, there's ASC appearing for the OPs, opposes the petition contending that all civil are bound to be transferred from one place to another, clinging on to the same place, not being in public interest. First, having so contended, he submits that if a direction is given, OP number 2 would look into the grievance of the petitioner. 2 or 4?
And 4, my lord.
OP number 4 would look into the grievance of the petitioner if she makes an appropriate representation. He or she?
He, my lord.
He makes representation, keeping in view the extant guidelines. First off, this is appreciable. Next one, the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate representation to OP number 4, seeking his retention at the same place where his spouse is still working.
Yes, ma'am.
Working. Semicolon. If such a representation is made, a call shall be taken thereon within at the earliest point of time, as early as possible. First up, till such a decision is taken and communicated to the petitioner, he shall be continued in the same school wherein he was working before the issuance of the subject transfer order. First, all contentions of the parties are kept.
Original certificate.
Yeah?
Original certificate copy.
Yeah. Today you will get it. Sir, not certificate copy, web copy to be acted upon. Web copy.
Lordship is in place of open number 4 my lordship director student mass education elementary education my lord, because the cost title is confused my lord.
Which OP?
Which director in that place is written as 5 my lord. OP number 5 written as 5.
It's not there.
My record is not.
In your papers he has not corrected.
Yeah, right.
But here it is correct. Yes, we should always correct that. Director of School and Mass Education.
Elementary education.
Director of
Elementary education.
Brother, you can rectify that.
Yes.
Here also you rectify.
Yes, my lord.
No, that is confused my lord.
All right. Give papers. Director of Elementary Education.
Elementary education.
That you write.
Director elementary education. That will suppose.
Take this one.
27.
Yes.
This is a matter relating to one sanction of one increment on national basis due for retirement before 1 day, my lord. Your lordship, the one decision they've taken as per the order of this honorable court, as well as the order of the honorable Supreme Court in special order. Yes, ma'am. The similar order, your lordship, passed. That is also annexed 7, and I corrected it also again.
Page 45.
Same order. Any changes to be made here?
I already changed, madam. I already corrected, madam.
Live law.
Yes, madam. Only another my prayer, madam. My prayer may be quoted, madam, in the order sheet.
In the order sheet.
Yes, yes. And this one.
Quote the prayer also. Yes.
The second item, my lord, that is a matter relating to announcement of a grade. 5 is pending. Only your lordship dispose of the consider my annexation 5. And my prayer may be quoted, sir.
Petitioner has scripted his prayer as first. Before knocking at the doors of the court, can you be seated?
Madam.
Petitioner has given a representation dated 16/5/2024. Specifically requesting which OP?
Not 2, madam.
OP number 2. OP number 2. How many pages representation? It is longer than case 1.
Pages.
OP number 2. Seeking release of financial benefits of third CPS into brackets increments in terms of extant guidelines. In as much as he has put in 30 years of service.
Yes, madam. 33 years of service. But he is entitled up to 30 years of service.
More than 30 years of service. First of all, he has also sought for adding one additional increment at the rate of 3% of the basic pay plus grade pay with 5,500 instead of rupees 4,200. First, counsel for the petitioner submits that if a direction is issued to OP number 2 to take a call on the subject representation, is line to this. Next paragraph. That ASC, having resisted the petition for some time now, agrees to instruct OP number 2 to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way if all contentions are kept open. First off, this is appreciable. Next paragraph. 8 weeks. Solicit. No worse.
29.
My lords, in this writ petition, my lords, the petitioner who is a class 3 headmaster belonging to senior grade tribal welfare education service, my lords, he has been deployed, my lords. The petitioner is challenging the deployment order, my lords. My lords,
Deploy.
My lords.
Means what?
My lords, that meaning is not in the service rules or in the Odisha service code, my lords.
No, by this what has been done?
My lords, he has been transferred from one school to another school. But my lord, the one problem is that, my lord, he has been transferred from high school to an ashram school. My lords, may kindly come to the Odisha education manual.
That is not permissible.
No, my lords, because he does not have a post there, my lords.
In the ashram school, there is no such
my lords. Because, my lords, may kindly come.
When transfer happened?
My lords.
23/9/25.
My lords. And then after
What
that,
is meant by ashram school?
Not that school is running by the SCST welfare department, my lord. That is not under the control of the school and mass education. That is also, my lord, by the same department they are controlling, my lord.
my lords,
Including my lord, the ashram school include the hostel facility also available, my lord.
My lords, actually there are three levels of schools: Sevashram, Ashram, then high school. My lords, it is governed under the Odisha Subordinate Tribal Welfare Education Recruitment and Conditions of Service Rules 1993. My lords, as per Section 3, my lords, the service is actually divided into two grades. One is junior grade Subordinate Tribal Education Service, another is senior grade Tribal Welfare Education Service.
You are in senior grade.
My lords, I have been in.
Ashram is a junior grade.
My lords.
What do you say, brother? The Apex Court said that by way of transfer, you cannot change the grade.
Only the administrative grade he has deployed, my lord. Not the administrative grade he has deployed, my lord.
No, what do you deploy? How can you deploy? You cannot deploy a civil servant to a lower post. If you want, you can deploy it to the higher post, not lower post.
Saying lower post, but I think not a lower post, my lord. I will take instruction, my lord. He has already relieved, my lord. Yes, he has relieved. He has relieved on next day, my lord.
24th, my lord. 318 page.
Very next day, relieved.
Yes, on the next day, my lord.
You take emergent notice.
Another one point, my lords, if I may please, that the competent authority who can pass such an transfer order, basically is Director of SC/ST Development Department, my lords, who is the appointing authority, my lords. As per the Odisha Service Code, Rule 54, Appendix 1, my lords.
Only appointing authority can do
Appointing authority has got the power, my lords. Appointing authority, in my case, as per Section 2, Clause A of Odisha Subordinate Tribal Education Service, is Director Tribal.
Who has transferred it?
My lords, Collector Rayagada, who is the transferring authority for the junior grade.
Collector is the administrative head of the concerned school.
Head of the district for everything. But when the rule says who can take the decision, only that authority should take the decision. He cannot take the decision at all.
Not sure.
I say that. Because he has made out a case for interim order. He says, you cannot deploy me to a lower cadre. Number two, you have no authority to deploy me at all. Have you made any application?
No, my lords.
You have not made any application.
No, my lords, I have not.
I issue emergent note. He said, requested notice for. Headmaster Ashram School comes to you or a separate notice?
No, yes, the same department.
Okay. Returnable within the full stop. Since matter lies in a narrow compass, come on, call this matter after 6 weeks. Okay. Item 30.
My lords, interim order is.
Where have you made application?
My lords, application is there, my lords.
But you said you have not made the application.
Interim order, I have not made.
You made the application.
Representation I have not made, my lords. Interim application is there, my lords.
You.
What is it? 18181, my lords.
Petitioner has the application in IA number so and so supported by affidavit. First, consent of the petitioner submits that an employee being a civil servant cannot be deployed to a post lower than which he holds by way of leave. Secondly, he also points out that the competent authority to transfer is not the district collector, but the SC/ST
Director of SC/ST Development Department, my lords.
Director of SC/ST Development Department. First, he turns the pages of the rule book and prima facie demonstrates the same to be true. Next, in the above circumstances, a strong case is made out for issuance of interim protection. First, therefore, IA having been favored, the impugned order of deployment for transfer is stayed, coupled with a direction to continue the petitioner in the school in which he was working. He or she,
he was
working immediately before the issuance of the impugned order. First, non-compliance of interim order shall be viewed very seriously in the next level of the proceeding.
Grateful, my lords.
Item 13.
May I please, Your Lordship?
Yeah.
My Lord, here the petitioner has challenged the inaction of the authorities for construction of a village daycare subcenter on a land other than the land which has already been demarcated for construction of the said subcenter.
No, where it should be constructed is a matter left to the engineers and corporators and other. How can you insist that it should be constructed only in such?
My Lord,
It is for them to decide. Are you investment? Have you made?
My Lord, I'm.
You have not. Have you made any investment? I'm asking a question to you.
My Lord, I'm the president of the village where the land concerned. I'm the president of the village Nimami, where the land has been demarcated for construction of the said subcenter.
What center it is?
Village daycare subcenter, Your Lordship.
Means?
For the welfare and maintenance of to take care of daily medical needs of the people, Your Lordship, of the village.
But a suitable government land is not available in the village. Nimani, as per statement of R1 Nimani, the land that Kalika Prasad has been identified by RI and provided to H&F department as advanced possession on the basis of now they want to construct it elsewhere. Not here.
Not here. But
that order.
Well, my humble submission is that the village Nimami is situated in the middle of the road, and it is connecting three more villages, Your Lordship, namely Adhikapalli and Kalika Prasad. And where they are now constructing the said subcenter, Kalika Prasad, it is situated in the corner place, Your Lordship.
But that order was made in January 2024, June 24th. Annexure 1.
Well,
now, what is the stage of the construction?
I have made a representation before the learned collector, Your Lordship.
Correct. But what is the stage of the construction now? Building is over.
I have no instruction yet.
Videograph or some photograph. Call up for 2 weeks. Petitioner to produce the present stage of the structure in construction. Okay. Item 31. It will be your Lordship.
My Lord, the execution case is pending for 14 years, my Lord.
14 years.
14 years, my Lord. Before the State Education Tribunal.
11 years.
General order. I filed it to 14, my Lord.
So 11 years.
11 years.
11 years is a very short period for courts. They need another 25 years.
It can be executed by the State Education Tribunal, my Lord.
But yesterday, lots directed already.
Yesterday we have.
Yes, my Lord. That is in duplicate.
That is item number 25. Kindly see the order. The clear order was passed by the State Education Tribunal. That was
I'm saying, we have said all these people should not come to court. All execution should be completed 1 year and report it to the Registrar General of this court, wherein which adverse entry in the service register of the presiding officer of the tribunal will be entered.
That is 6 months, my Lord, as the Honorable Supreme Court.
Correct, but that again is in review now. That's 6 months. 1 year Rahul Shah versus so and so. 2021 Supreme Court.
No, now, my Lord, that is it.
The next one is 6 months.
6 months.
That is now in review.
Under review, my Lord.
Under review. Therefore, let him decide it at least in 9 months.
If you fix a date, then it can be decided, my Lord, within 3 months, my Lord. Also.
3 months, he will jump to the second floor and
matured. It is a matured case, my Lord. It is completely matured case on all sides.
So make it see. Disposed of. Yes. Item 32.
My grievances. The petitioner class 12 student.
Class
12. Student. At page 13, my Lord, if you sees, he passed in all subjects, but in theory, chemistry theory, but last but one line, chemistry you sees, he secured only 13 in theory, but in practical 13. And thereafter,
13 plus 30, it will be 43.
Next column is 43, and it is written RT. Repeating theory. That is clarified in last line itself. Repeating theory.
That is not true.
No, that was done. I was allowed to appear in the next examination. But this time, again, unsuccessfully, he secured 12. So he applied for the next session that is coming up in April, May, or sometime in the next. The application for that was closed on Friday at 11:59. I submitted application, repeated applications. That what the record shows, record not found, which can't be. I was
emergent notice.
Madam, but since because the notice, the last date was the online mode was closed, I may be permitted to take file the offline mode. Madam.
Have you made any interim
Application, madam? Yes.
Examination.
For examination, madam.
When the examinations will begin?
The examination will be in February, March, or April.
Notice let notice be served and then come back.
If you let's say permits me, the counsel for CBSE appears may be taken up the day after tomorrow. Or
issue emergent notice. First off, in addition to taking usual steps, issue notice by trustee as well. Costs are paid by the petitioner. Post immediately after service.
But I'll solve it by today itself.
Yeah, that's we have said, not you. Some court messenger will take that. Suppose if you take it, they say, I will not take.
Correct, madam.
That's therefore make payment first.
Yes, I'll do that.
I'll post immediately after service.
Madam, well, date may be fixed. Not otherwise they will.
No, immediately after service. Yes.
Item 33.
Cost by today, madam.
Item 33.
The petitioner prays for to release the total area salary, my lord, which has been calculated by the block money. Initially, the petitioner took shelter before the Orissa Administrative Tribunal, and the tribunal has passed an order to give all the areas within a period of 4 months, my lord. Thereafter, the work has been abolished, my lord. Therefore, the petitioner took shelter before this honorable court, my lord. This honorable court again, my lord, passed an order in WPC number that is
16,610 of
20, my lord, to give further 3 months time to comply the order of this honorable court. But thereafter, the opposite party did not pass an order. Therefore, the petitioner again file a content petition, and after filing the content petition, the petitioner, this honorable court is again to comply the order for another 3 months. Thereafter, the opposite party number 2 has sanctioned.
Take notice, Mr. G. Why this is happening? How many times he should come to the court?
The third time he has come to the
court. He requested to accept notice for all OPs. Since matter lies in a narrow compass, and also because the petitioner has been before the court several times, call this matter in the 3rd week of November. First, in the meanwhile, it is open to the other side to file their counter. First, pendency of the case will not come in the way of reporting compliance. Okay.
Item 34.
May I please, Your Lordship?
Yes.
Your Lordship, the third RSCP has not been sanctioned, my lords.
Disposal order अच्छी कोटा दोना दे भेजे.
Disposal, my lords, I have filed an representation, but also the order under annexure 4, my lords. Yes, my lords. They have sanctioned me second RSCP benefits, my lords. Kailash Chandra Behra. They have sanctioned me second RSCP benefits, not taking into account, my lords. That similar matters, my lords. Your Lordship has issued notice, my lords.
Issue notice, emergent notice. Mr. G accepts notice for all OPs. Call this matter along with WP number. Take that. Yes.
Item 35.
May I please, Your Lordship?
Yes.
It's my Lordship, it's a second contempt. Your Lordship, kindly see
Instruction in this matter.
page 9.
I will take instruction what they have done.
He accepts notice. Since this is a second contempt matter, comma, all the same, in the second week of November. First off, in the meanwhile, counter may be filed. First off, pendency of the petition will not come in the way of reporting compliance of the order in questions. Okay, can we reassemble after?
One I'm waiting for the item 32, received by Dusty, only to OP number 1, who is in Vocational.
OP number 1.
OP number 1.
Other
orders examinations.
Other
which is the chairman at Delhi. The other one is the school. They have nothing to do. CEO, control of examination will do.
But the notice has to go to them.
Notice
only for OP number
1.
OP number 1. For others, emergent notice by speed post. Okay. Post immediately after such. Challenge that order. By yesterday, I made an answer. Can it take today? With my lord from 54. The third item. There is a page of cases. I don't know the cases, but on which date? That was on 13/5. I was forced to relieve from that. That was. But 5 months are over. 5 months are over. No, that will post them for some. This the matter itself. I have posted them. I think in November first week. Today it has come. Today it has come. All matters have come today. Yes. That will be well. My friend, my learned friend,
I have to file a counter in this case. One counter is filed by the district office, but government is to file counter. So your lordship, I call this matter 1 week after any date. I will be ready by then.
54.
Yes, 54.
Yes.
54. Convenient date, your lordship, kindly give.
12th November?
12th November,
or 28th of October? Yes.
28th November will be better.
Then my client has not been.
There will be holiday. They have been district.
I don't for them. On 10th of November, we will do that.
Yes.
Okay.
They were protected all. Interim order is there.
For 9. Yeah. That is no. There is no interim order. That is my engagement. 59.
Yes, sir.
59. You want time?
Yes. No, not time. I want hearing.
You want to argue?
Yes.
May I submit before my learned friend begin sit? I have got an item of 44. I don't want adjournment. If you lordship can please get me 2 minutes time, I'll complete it, my lord.
Which one?
Item 44. I am almost surrendering after 8 rounds of litigation. I am surrendering.
Sir, it will reach. It will reach. It will reach shortly.
Reach, my lord. Because of my illness, I was just requesting your lordship. Can it be 2 minutes before 59?
Can we take because he says that he's not
calling. I'm calling the lordship. Kindly pass over. I'm calling Mr. Mahanti.
Kalman. Yes.
Item 59.
Item 59 in the connected matter, Lordship, I am appearing. I have already appeared, in fact. So there, we got notice from my learned friend that matter will be taken over 2 p.m.
Yeah.
It was yesterday before your Lordship in the connected matter, the first item. So both have connected, will come today.
Yeah.
Now your Lordship may see the previous order where the notices have paragraph 3 of your Lordship's order. Notice is sent to opposite party number 3 to 6 by registered post with AD. Within 3 weeks, requisitive shall be filed within 3 working days.
Yeah.
We filed it, my lord, but that has not gone to my lord's registry. They are the service provider who have given us employment. So I think your lordship would agree that their presence is required. Because they...
Notice is not sent to them.
No, your lordship will look at the office note. Today's office note.
Not sent.
Because that, my lord, change of government's policy regarding abolishing registered post and speed post. So we have put in with speed, registered post. So now in the mean speed post, the differential amount is to be paid. So we have to put in the differential amount.
Okay. You will do that now?
We'll do it by today. By today or tomorrow, as soon as the file returns.
In fact, they are the vocational training provider. Here, the policy of the government has been challenged. And pursuant to that, your lordship has stated the Annexure 7, that is nothing but a timeline was issued, dates of selection, the procedure. That is, your lordship has stated that as a result of 3,100 or more posts have been halted.
These are all temporary employees are sought to be displaced with temporary employees again.
1 second. How many of petitioners are how many?
Petitioners in both the cases are 19. 19 in total in both the cases.
Both the cases?
19.
So far as that interim order to is confined, we can say 19 posts will keep vacant.
Yes, your lordship can say, but your lordship may kindly see that Annexure 7 they have challenged.
Annexure 7.
It is not a they have challenged.
If your lordship is not.
Just a minute, please. Annexure 7, page 71 to the reflection.
71 again. Peter.
Your lordship got that?
Yes.
This is a timeline.
And in many cases, that time is gone now.
So interim order has become infectious.
Then your lordship, next page. That I want to show your lordship. Clause 5.
Priority shall be
according to the existing vocational trainers and vocational coordinator during the selection process. Their apprehension is that when the tender was issued by the agencies, they apprehend that their service will be terminated. But the government has categorically, by the Annexure 7, directed to all the managing directors, opposite party number 3 to 6.
Priority to the existing vocational trainer.
Yes. They are continuing.
No, if you say that they will be continued, I will record that.
That they won't say.
No, if he says that.
They won't say that. They won't say lordship. I say, my lord, it is not a question of 19%.
That's the answer, my lord.
I will answer. They should have said that. That will keep all these people. My lord, there are 2,020 people before lordship. You must not. Mr. Lanka, let us be fair and clear.
I am already clear and clear. Your lordship may pass order taking note of that.
At this stage, your lordship may not modify the order. At this stage, why I am submitting my lord?
I have already, but I have some reservations. I have talked with them. We have no hesitation to keep them in here. So on the basis of this, your lordship may pass it.
No, this order.
He is saying he will continue.
Yes.
I mean, your lordship. I heard your lordship may hear him now.
He agrees with your contention.
My lord.
And still you want to argue.
Not arguing, your lordship. I am showing my lordship own order.
That's all right. Now he is saying, yes, we will not discontinue these people, we will continue you people. Still you want to argue.
These 19 people are protected, my lord.
Yes.
Why I am arguing a little further. There was an association before my lords in 22418 of 2025, page 67. There, your lordships dispose of their petition, dispose of their representation in terms of that Madhya Pradesh judgment, your lordship. MP judgment, that is Dipti Pandey, your lordship knows that one set of temporary employees cannot
be substituted by another.
No, in that case, my lord, in the MP case, the Hon'Ble High Court has remanded the matter for reconsideration.
No,
ratio has been decided.
No. Ratio is there at the division bench of this court. I will place that, your lordship.
No, Mr. Saraki, I understand. Assuming that what he says is true. Still, what he says is the existing employee shall be continued.
I would have no question, your lordship, dispose of employees, whoever are there, say working since 2016, if they are retained and further employees are taken, I have got nothing to say, my lord.
That your lordship may pass order my concession.
No, you give in writing what you want, what you have said now. Give it in writing. I will make it a part of the art. Whatever you said now, it is available online also.
Yes, on the
Give us in writing 2 lines. In terms of that, I will dispose of the petition. That's what he wants, nothing more than that. His grievance is that you are not putting it in writing. You say it in writing.
No, we have, in our counter, we have said that priority shall be.
Priority means.
That's why my respectful submission before Lordship, on the basis of that clause 5, that priority shall be given, your Lordship passed.
No, priority means what?
But in the selection process, they have also applied. They have also the participants.
Yeah.
They are just only considered.
On priority basis.
Yes, right. That is,
No, Your Lordship, not acceptable. Your Lordship, why I say?
Your Lordship, we have no agitation. But there is some reservation point which
What I said, Your Lordship, that you won't say that. That is what I say.
And if your Lordship will pass, we will honor your Lordship. That is my submission.
Before Your Lordship passes in,
My Lord Senior is trying to linger in the matter somehow.
how so? Why you are making us person? Your Lordship. Yes, this one we have to come there after
Right there,
rights I'm saying. They are not hearing us.
agency, my Lord.
My Lord, and that outsourcing agencies, why the notices have been issued, they are not sufficient. That is what I was saying, my Lord.
No, that's all right.
Your Lordship may look at this order, division bench of this High Court's order. He says Madhya Pradesh he has got reservation. That is not what he says, is not correct. Your Lordship may look at. Division bench of High Court, I will take your Lordship straight to first paragraph, my Lord. The case of the third paragraph, the case of the petition is that he has passed the degree course in architecture in the first class pursuant to the advertisement dated 25/7/2009 for the post of lecturer in architecture issued by the Principal College Engineering such and such. Opposite partner, he appeared at the interview. In the said interview, he was elected on 29/8/2009 by an lecturer. For one issued an office order appointing the petitioner as a lecturer in architect such and such on contractual basis. On 8/7/2010, opposite part number 2 issued an office order such and such. I am skipping that, Your Lordship. Then I am taking my Lordship the last but 3 lines. Thereafter, he was appointed for the current semester 2012-13 up to 31/12/2012 or till filling up the post by regular appointment as he had continuously and satisfactorily worked as a lecturer for 3.5 years. Instead of filling up the post by regular appointment, a third advertisement was issued for the same post on 19/12/2012 had annexure 6. The petitioner again the same. He further stated that third advertisement was issued to accommodate some candidates on extraneous consideration and the same is qualified. Pursuant to the issuance of notice, I am skipping that for the timing, Your Lordship. Then my Lord may kind to turn to page, next page.
How long, what is that they are doing now?
They are already trainers since 2016.
2016. Yes.
Then my Lord, second, Your Lordship may look at this paragraph.
Slowly. I am not as fast or as years as you are.
My Lord is way ahead than us. Secondly, an ad hoc employee.
Short note.
An ad hoc or temporary employee should not be replaced by another ad hoc or temporary.
That has long been set. That long has been settled. Any student of service law will know that. That will not.
So this being so, you want to change this priority? What priority, my Lord? There, this person had appeared and they had failed. Still, the Lordship said no. Everything is passed.
Yeah, you too have applied for the post in question?
No.
You are not applied. Now they want to bring other set of employees.
Yes.
Contractual employees
Yes.
in your place.
Yes.
Is it true?
No.
Regular appointment.
No. Through agency and contract.
Outsourcing.
Consolidated amount are paid.
Outsourcing.
Same process.
The central sponsored scheme funded by central government. And the object of the scheme I have given also.
Had it be regular employment, I have got nothing to say.
To whom notices have gone?
This service
service provider. How they are necessary?
They are the persons to whom they have
They are
selected.
only agencies.
They have selected. Now those agencies have changed.
Correct. But
Now your lordship knows the obvious purpose. Government went, new set of government came, something. Your lordship was saying in one case also, your lordship knows all these things. But question is,
no, how you are concerned?
no, I am not concerned. I won't be there. My agency come. I won't be there. That is the whole thing, my lord. Whole purpose is that.
But now they are saying that priority will be given to you.
Priority won't suffice, my lord.
Yes.
Appointment is to continue. That is my lord's
These 19 persons.
Others are not in this writ petition, I cannot say, but in the other case which is association filed, your lordship had directed them to consider the representation in terms of Madhya Pradesh judgment.
Yes.
But that is yet to be decided, and they have proceeded with this.
You have not. They have not considered that.
That your lordship may can see. Go in my note.
Very.
So where is the counter? Your lordship may ask. Where is the counter?
Paragraph 1 on my note. The prayer is to quash Annexure 7 issued in violation of direction dated 18/8/25 passed by WPC number 418 of 2025. Your lordship has passed this. To direct opposite party number 2 to allow existing tenants to continue in their respective places on ground of having vast experience in similar field in terms of Annexure 3 order of MP High Court. That they are relying. So far, prayer number 1 is concerned. Respect to submissions are that in fact in the fact and circumstances of the case there is no one while issuing the Annexure 7 as alleged. On 18/8/2025, this honorable court disposed of the writ petition number so and so, directing to dispose of the representation dated 28/7/2025, granting 6 weeks time to take a decision. An interim measure directed not to take any coercive action against the petitioner. You not directed that. Pursuant to the same direction, while the matter was under consideration and before the stipulated time period of 6 weeks expired, as granted by this honorable court, petitioner again on 2/9/25, after 2 weeks, approached this honorable court by present petition just after 2 weeks, alleging violation of direction dated 18/8/25, passed in WPC number so and so, and prayed for passing of Annexure 7, which is 30/8/25, a timeline issued to initiate process election and the recruitment of vocational coordinators and vocational trainers. Your lordship disposed of to consider their representation and no coercive action will be taken against it. Then, after when matter was under consideration, just after your lordship granted 6 weeks time, just after 2 weeks, completion of 2 weeks, then again they approached your lordship that they have violated, the state has violated your lordship's order, and Annexure 7 may be stayed. By that time, the implementation considered. And your lordship has stayed, and all the process of selection of recruitment were stopped.
No, I confine this interim order only to the petitioner.
Petitioner, no coercive action to be taken, your lordship has said.
Correct.
Nothing else.
Yeah.
Your lordship has not
not stalled anything.
Yes.
Now they are here. Now what I will make is, there are 18 persons. Now.
Yes, 19%.
19 persons.
Yes.
This whatever interim order has been granted,
yes,
is confined to the petitioners before the court.
Yes.
Right.
Yes.
Your lordship is disposing it of.
Yes.
We'll dispose it off only. We are protecting you, and it will be disposed of.
So our service will be protected.
Your service will be protected in terms of clause 5. Priority shall be given.
No, priority. That is for that your lordship may have to hear the matter. Yes, your lordship.
Yeah.
My lord, while issuing the notice, because while what I say, your lordship, giving priority is something different than continuing my services, my lord. Whatever servicing I mean.
But Mr. Renka, what is meant by priority? Let me clarify.
Yes.
By priority.
In the selection process, priority shall be given to this one. This box. In the selection process, their case would be given priority.
Means what?
Means your lordship may say priority means they will be they are continuing. They are eligible, they are continuing.
You have used that word priority.
Yes.
It is not a statute. If some officer has a
Yes. The project.
What is he having in his mind when he employed this word?
Their case will be considered.
Means what?
For recruitment, obviously.
On priority basis.
Yes.
Means what?
Obviously their case will be considered.
No.
That is not what it is.
My question remains unanswered.
Yes, sir.
By your submission, it is not a complete answer to my question.
Sorry,
What is meant by priority? Ask Mr. G, what is meant by priority?
Priority means, my lord, first they will be given chance for a engagement, thereafter others will be engaged.
They will be engaged thereafter for whatever
recruitment process is going on, they will be engaged. Other candidates.
Priority will be given in selection process.
Unless these English words sometimes will play a lot of mischief. You will say priority is given. Well, actually, unless you say what is meant by priority, they will not be satisfied.
Annexure 7 is a selection timeline for a selection process.
Yeah.
In that Annexure 7, it has been written.
They don't have any respect for the court's order. Your Lordship directed 18 to consider representation. They come up with an advertisement on 30.
No.
Just wait. I am submitting to the court. I am not submitting to you.
Every respect.
Sir, your Lordship passed an order on 18-8 in the earlier writ petition to consider my representation. They have come up with the notification on 30th of August. They say now 6 weeks had not expired. How did they come to the court?
The court had a protection.
So your Lordship, no, that protection came later. Protection came later.
When your Lordship.
Where is the interim order?
Interim order, your Lordship, 9/9/2025. Interim order very clear, my Lord.
What it says? No coercive action shall be taken.
Yes.
Order number such and such, senior counsel such and such, to the earlier order of court. This is important, my lord. Appearing for the petitioner draws attention to the court to the earlier order of this court in WPC number 22418 of 2025, disposed of on 18/8/2025, wherein consideration of petitioner's representation in the light of WPC such as Dikti Pandey case, my lord, disposed of in such and such were directed. A prima facie case is made out for granting provisional protection since the very breadwinner of the petitioner is at stake. Right. In the above circumstances, the application having been favored, the impugned order dated such and such 30th/8/2025.
Heard counsel appearing for the parties. First, learned AGA Mr. Lenka submits that the interim order is too broad and the entire process has been interdicted by its breadth. First, he further submits that the interim order be confined to the petitioners, as has been observed by Apex Court in a Keteno decision. First, the senior advocate appearing for petitioner submits that if the services of his clients are continued, they have no quarrel with the OPs. First, next time, in the above circumstances, the interim order dated
10/9, my lord.
9/9/2025 is confined to petitioners. First, eventually, the process in respect of others would continue.
This order will be in the first case as well.
In whichever case.
No, both the cases. 19 both the cases.
Yes. In other cases, how many members?
They are 9, here 10.
Yeah.
No, this order may pass.
You continue them, the rest of the people you go for the process.
Problem.
Yes. Yes. Sir is not well. Yes, sir. Item 44.
From my 7 rounds of litigations, I am now surrendering myself. Small note.
Yeah. Who is your opponent?
State.
Yeah.
This dispute is continuing since 1997 regarding recognition of a school.
What is the case about?
Regarding recognition of a school, my lord.
Recognition
Of a school.
Recognition is granted under which section of Vocational Act?
Section 6.
Section 6. Give the dedication. Recognition is not granted to you.
No, a long term, my lord. There are several objections have been raised that there is no property has been there.
126 paged. 126.
Ultimately, my lord, I draw only two dates, my lord. Before also you can turn to next page.
Sir, can we read the prayer column?
Yes.
We only read prayer column. Quashment of order dated 26/4/23. Annexure 7.
Yes, my lord. You also kindly turn from to the last 4 lines of the prayer. Within a stipulated period and to grant permanent or temporary recognition to the petitioner's institution in accordance with Section 6 or subsection 9 of Section 6 of Odisha Education Act in order to save the institution and career of the future students. What happened, my lord, if your lordship kindly turn to page 2 of my note, all this process has been going on. There are 7 rounds of litigations. Also, that is rectified. Another objection is there. Serial number 11, my lord, page 2. Ultimately, my application was rejected.
Rejected on what ground?
Rejected that I have not complied with the criteria required for recognition, that I don't possess any
Basically,
school,
non-availability of the infrastructure.
any school room, etc.
What is the infrastructure required?
Well, 6-9 clearly specified.
So then,
These are page 127 of this act.
9.
Yes.
Where a private institution is not land, building, and furniture. But the committee is reasonably adequate provision for accommodation and important inside. To grant temporary permission for a train not receiving was not receiving 7 years in aggregate. The application for extension of temporary residence shall be made expensive in the same manner as an application for a permanent residence. No extension of the residence shall be granted unless the house is by the agreement and the reason of the death of the condition. That any private institution will receive residential. You have not been given temporary recognition also because it was granted on which date?
Temporary recognition was granted on 19/8/2000. Well, in the meantime, what happened, my lord? I have procured the lands. Because earlier what happened, my lord, the lands have been donated to me by donors. But they say that we will not register it unless the school is recognized. We want to register it in the name of the school. Ultimately, they have registered the...
Registration happened. Registration happened then?
Your Lordship, I kindly put on to... I am not speaking much, my lord. Page 2 of the note, my lord. It starts from 11. Item number 11. 29/3/18, application rejected. On 29, another 9, challenge in writ application. Then 25/19, another 11, page 18, representation to the High Power Committee. Then another 12 is the concern. Representation was rejected again. Item 11, 2/8/19, representation rejected. Then another writ application was filed. Then order of rejection was rejected.
Send is dated 26/2/24.
Yes, my lord.
Brother Hon'Ble, what was the reason why you denied recognition earlier?
Only on the ground, under 6-9, there is a specific provision. What are the basic requirements?
What are?
My lord, they don't have the, so far the land is concerned.
No, so that question goes, they have bought the land.
No, they have not applied. For that purpose, my lord, see the next para. But my learned senior friend is...
Come to item number 17 of his note.
17, exactly.
Yes.
18, page 1-1, held in the name of the school.
The name of the school.
In the year 2024, my lord.
Yes.
Then 19 in the school 040 decimal, this land in the name of the school cannot be transferred. Therefore, fresh application with temporary recognition. They want this much. They have to make a fresh application for the recognition that be considered by authority keeping in view these recent developments so far the 24 and the all other infrastructure development. This is only 24 it happens. That my scenario is saying.
The first one is, sir, 1 second. Just I want to take out my decision and
apart from that. Which honey? Look it.
you can sit and argue also. You can sit down and argue. No problem. Sit down and argue. I can see. You got petition. One similar matter which I treated in Karnataka. Matter went to Supreme Court and Supreme Court has approved it. Can you get that? Can we have this matter next week? I will bring that judgment which favors you. I forgot, my memory is playing trick with me nowadays.
In addition to that, in this super we have filed also the counter. There are in also 2 government schools in the nearby. That's in it. But my lord, these are all the that we have taken the ground also that the facility of feasibility and 2 government schools are functioning within 3 kilometers of the radius.
Whether there is any prohibition.
And the feasibility of the students, availability of the students is not as per the requirements. But there are other 2 to 3 things are there, my lord. My lord, sir, let them for the next week with that decision. But these are the shortfalls. If at all they want to go for a fresh recognition along with these availability requirements.
No, then also you will say there are 2 schools and therefore we will not.
That we have said, my lord. That we have said.
Where is the question of remanding? Like, either this side or that side. Remand after remand after remand.
Fixed date in the week, my lord.
Sir, we will have this matter on 3rd of November. All right. In the meanwhile, you get to that Karnataka.
Yes,
Ultimately, beyond record, my lord, this particular case has got some political color in it, therefore has appliancy.
For school also, what I held in that matter is the approach of the government for establishment of the school at the hands of private people is different from the approach to establishment of a wine shop. This is the sentence which I have written in that. If it is a wine shop, you can reject the application. You can say we will not grant sanction, etc. But a school, it has many, the established
basic requirement for the development of the unit. But since last 1 decade, my lord, in our state, my lord, we are now developing other schools in comparison to English medium schools. So far the schools are concerned. My lord, government is come up since last 10 years, my lord. Be it the changing of the government, prior government, it's not making no difference, my lord.
No,
so far the development of the education is concerned, government is taking much priority and taking the viable steps. How it will be convenient for the dropping out students also in the ground level, my lord. But at the same time, we have to adhere the conditions, rules, stipulations that beyond that we cannot travel, my lord.
Most difficult, I have procured these lands. These lands are in the name of the school. However, the record of writing in the name of the school. I cannot sell the land to others. The land will become idle. The schoolroom constructed there will remain idle.
Just look into, sir, that judgment and make that also.
Item 36.
Yes, there is a direction to file the consolidated rate application after my amendment was allowed. Unfortunately, I could not file it within the stipulated time which is also granted. It has been filed today, my lord.
Today you have filed it?
Copy also has been served.
Yes.
So can be taken up this week.
Next week we have difficulty. We'll have it in the second week of November. Second week of November. Get the request now.
Item 37.
My Lord, I have challenged the selection process, requirement living teacher for government school, secondary, and TGT ODI. Selection procedure has been challenged of TGT Arts and TGT ODI. In similar matter, your Lordship fixed it to second weeks of November. There is an interim order.
Started in this.
Yes, Lord. No, my Lord. Only state.
State in the party.
Yes, Lord. State and selection.
State and commission committee.
My Lord, is
Staff collection commission. Is it staff collection commission means a statutory body or a constitutional body?
No, statutory body. I can answer one.
The GX of notice for one. Learned council accept notice for two. Call this matter along with the WP number.
12,869 of 25. The interim order, my Lord, for 11. I am here.
Any application is moved.
Yes, sir, there is an interim application. 13,469.
Application line number 13469 of price of by applicant seeking interim protection.
In that case, I was the entrepreneur. In the other case, what he my learned is referring. There was this absolute stay initially that we have entered the modified. So now by this process, my lord, if my lord will, because that case was pending when filed much before, my lord have directed that the equal number of posts will be kept reserved. Now if the new cases will come.
No, this is
not in this case. In that case, where my lord have modified that order, my lord, by this process, my lord, any person will come.
Who are you?
We are the person already.
In this case,
in this case, that is why
then you confidence.
But what my learned friend would have said, he is not saying that.
No, he has given a modification answer. That order also he has given.
Yes, modification. What he could have said, I am saying.
Put it by counsel for the petitioner. Draws attention of the court to the interim order dated 9/10/2023 contained by a coordinate bench of this court in WPC 12869 of 2025, which has been subsequently modified on 9/10/2025, confining its operation to the parties in question. First of all, he further submits that once interim protection is granted to a set of people, litigants, similar protection ordinarily cannot be denied to other similarly situated set. First of all, there is force in this submission. Next question. Therefore, application is favored and the protection as has been granted in the cognate case is extended to the petitioners here. 37. But that is injustice.
Item 38.
May I plead the lawsuit?
Yeah.
The last occasion, we have directed me to copy service.
Yes, service copy. I have also
Like the only limited, my lord, my arrear salary is pending. Like the correspondence are there. Your lordship may dispose of my references are annexed 6 series are pending, my lord.
And they are my applicants may not noted because what happens, we have panel counsels. Unless we file a Akalat,
you backed up here.
Yes, I have talked with them yesterday night after seeing the list. They have said you take 1 week time so that we can send you or else your lordship can dispose of that without recording my applicants.
How can it
be? It will be known to people, whole world knows that the judge has written a wrong order. Not false
That
one.
is my problem because unless I
will have it next week. Call this man on 3rd of November. 3 sites are there for it. Yes.
Item 39.
Might be there.
Yeah, Lordship, I'm a clothing company. Which had clothing company. Cloth, fabric.
Fabric company.
Fabric company. I had hired a transporter for transferring my fabric from Chennai to Noida. In one of the trucks, Noida. In one of the trucks, the transporter was supplying ganja. Kept separately. My fabric rolls was kept separately. The ganja was kept separately. However, my fabric rolls was in the year 2020 seeking release of my fabric rolls. The court, while observing that I am not an accused in the case, I have no link with the accused, directed for release of the fabric roll, but asked me to furnish bank guarantee and stated that upon conclusion of the trial, the bank guarantee will be released. Now, Your Lordship, the trial has concluded against 3 accused persons. There were 4 accused persons. One is now absconding.
The split trial.
Split trial. Against 3, the trial has concluded. One is absconding. In the judgment, all the 3 accused were acquitted. The lower court has stated that the prosecution has failed to establish a case. Now, even if the 4th accused is apprehended, most likely he will also be acquitted.
That we don't.
Your Lordship, but I do not have any linkage with the accused. I do not have any control with the accused. I am the owners of the fabric rolls. I am only seeking my bank guarantee may be released.
Bank guarantee to be
released. For the last 4 years, year after year, I am renewing the bank guarantee of 45 lakhs, Your Lordship. And no observation with regard to me or the fabric roll.
Judgment already. Anywhere in the charge sheet.
Yes.
Charge sheet is filed against all the accused.
All the 4 accused.
Not
the accused.
Anywhere anything is stated about.
There's no iota of allegations against me.
Ganja does not belong to you.
Even it is stated that fabric rolls were never used to conceal the ganja. It was kept separately. And the owner of the fabric rolls have no linkage.
Who appears for the OPs?
The state will.
State. Mr. G, take notice.
My lord, notice was issued earlier on 8/9.
Notice? No.
This is coming from the second.
After notice matter.
After notice matter, my lord.
What?
Give me some time.
Okay.
I can get instruction in the matter. Otherwise,
any short date.
Short date. It was
10/11.
10/11.
10/11. Okay. How courts have viewed? This is like an order under section 457 of CRPs.
Yes.
As well CRPs. How courts have viewed when split trial takes place? How should these?
No, unless and until I have link with the crime of the offense, my fabric rolls or my bank guarantee can be kept. Here is a case where the conclusion of trial says that I have no link.
Therefore, you cannot wait. Any other property guarantee you can furnish. Now, if you furnish bank guarantee, then you may have to pay something. You will incur some interest, etc.
That is what I'm doing, Roshan. Every year I'm doing it.
That's all. Instead of that, give some property guarantee. We'll modify whenever that man comes.
But it can go on forever, Your Lordship. If he is not apprehended, then
no, at least with liberty for modification of the order. If that person is not found within reasonable time.
No, that way I can do. I can take instructions and come.
Just the patterns you.
I can take instructions.
May I please?
Yes.
Propose petition being an employee, my lord. Under Annex 1, my lord, as a sweep at the Arrear Cancer Center, my lord.
Structure of your sentence. It is lot of jugglery is done in our court. I do not know why so much jugglery. He proclaims it is in trash it. Set aside. This should be the prayer. If you do them, if you ask them to do, if they do not show the cause, then you do this one. I do not understand so much jugglery. Public auction. Well, what is this matter? How?
Matter is
proclamation dated 10/9/25.
Yes, Annex 12, my lord.
What is that proclamation?
Proclamation was issued by the State Level Scrutiny Committee, my lord. Regarding my caste certificate, one allegation was raised regarding my caste certificate. For that reason, my lord, the State Level Scrutiny Committee issued your lordship mechanical glass to Annex 11, my lord.
So I issue notice so that.
Annex 11, my lord.
Yes.
Issue emergent notice, Mr. G accept notice for the all office. Matter lies in a narrow compass, calling the 3rd week of November. Okay.
I have filed and miscase, my lord. Otherwise, my lord, after proclamation, then we first file.
3rd week of November it is coming.
So let
interim order be passed.
We'll dispose of the matter itself. It has to be covered. No coercive action.
Oh, yes, my lord. Otherwise, my lord, they may, after proclamation, they may pass the final order.
Yes, Mr. G. Otherwise, it becomes infraction.
Yes.
An application in I number so and so supported by affidavit is filed, seeking the interdiction of further proceedings pursuant to proclamation dated 10/9/2025 issued by the Deputy Director SLSC Cuttack, namely OP number 3. First one, counsel for the petitioner submits that if a further process is undertaken, the same may render the petition infructuous. In addition to he is blind to prejudice. First, there is some ring of truth in this. First of all, circumstances, the application having been favored, the further process pursuant to subject proclamation is halted till next day, the 3rd week of November 2025. Yes. Item 41.
Item 41, my lord. Last token, the lordship directed my lord and senior to serve copy, my lord, and he will take instruction. This is regarding, my lord, of trade teacher science, CBZ, my lord.
Revised the final,
my lord. In this case, I am only playing that, my lord. In respect of one question, I have answered rightly, but the staff another answer. That answer I am disputing, my lord, with the supporting textbook, my lord. Only one question, my lord.
What is the prayer? Prayer, I don't understand.
My lord, in this case, my lord, what happened, my lord, after the main examination, the plan of examination, preliminary, main, and thereafter, my lord, certificate verification. As it has been presented.
3 stages, yeah, stages.
Sorry.
Three stages.
3 stages, yes. So, my lord, out of the 3 stages, in this case, this is with respect to the second stage.
It is a written main examination.
My lord, here, one question was there. The question is 149, I think.
149, page 49.
There, my lord,
page 49.
A particular question was prepared. It is a multiple choice question. So A, B, C, D, my lord, the 4 answers, probable answers are given. Now, he put the tick marks against answer A. And what we have provided in our website, my lord, with regard to that select key, my lord. That is
model answer.
Model answer, my lord. That is, answer is D.
Not A.
Not A.
What is that question?
Yes. My lord, may I be permitted to read that, my lord?
Let us see that question.
Yes. The question is, my lord, the last end of, the terminal end of spinal cord is called. It is at page number 49, madam.
49.
Yes, ma'am.
Question number 49.
There is no 49
the end of spinal cord is called
Filum terminal, epinema, coccyx, and conus medullaris. Medullaris, madam.
The correct answer is D.
It is D.
According to me, it is A.
It is D.
Why is the standard medical book say?
Well, that is what madam is submitting.
Yes.
Well, on the basis of the medical books, because I do not have any specific written instruction from the staff person because I have received a copy of the paper book, but out of my own curiosity, I searched it in the Google, so also referring to the different textbooks, there must, the answer is D, not A. It is the thread. The answer A is actually the last thread, not the last end, The end is always, may I be permitted to share this particular paper, which is
Conus medullaris. Yes. It cannot be much.
No, I am not. Why I am saying so, it is also, what I have also downloaded. Now, I am coming to the second point, What your lordship may tell. It is the structure of the spinal cord.
You have not brought full answer at all.
No, my lord.
Something is missing.
This is actually when I put a question to the Google, my lord.
That will tell like that.
My lord, the answer is like this. Now, my lord, what he has
there is a famous book by Gray's Anatomy, like our Salmon's jurisprudence. The medical students study Gray's Anatomy.
Yes.
In that, if you ask Gray's Anatomy, they will tell, any professor will tell that.
My lord, only one submission. What he is relying upon. His prayer in this case, my lord, his argument in this case, as it has been advanced in the writ petition, it is twofold. One is that, my lord, because this particular answer has been figured as wrong answer, that is why not only minus 0.25 mark is there, but also 1 mark has been deducted. So if this will be...
The negative valuation is there.
He is
no negative valuation.
He is praying for 1.25 mark extra. So why he is making upon a particular... he is saying that it is a book, but it is at Annex 7, page 53.
Is it a prescribed book?
That is what I am telling.
Approved by the Council of Higher Secondary Education.
It is a textbook. What my submission, it is a textbook. The first page says.
Correct. And textbook of fundamentals of
Zoology 1.
Approved by Council of Higher Secondary. It is approved by government, my lord.
But what he is relying upon, not the textbooks context. It is why it has not been done, but I will not say anything. But it has what he is relying upon. He is relying upon the model questions which are subsequently attached to the textbooks, my lord. The model questions and the answers. There, my lord, one of the model questions, my lord, in page note 54, the question number 14, my lord.
In your bar, no doctor is a lawyer.
No doctor.
No doctor.
Well, we can.
In Bangalore, many doctors have become lawyers. Many of the doctors practice. So if available, I would have asked them. So this book we cannot much bank upon is your version.
My version, it is not this is not a part of the textbook. This is not the contest.
We'll ask your head of the department of that particular person. He will answer.
This matter will be taken out. Next week, my lord, on 15th, my lord.
15th.
Next week on 15th, my lord.
Next month.
Sorry, my lord.
Your October.
It is next, my lord, on 22nd.
22nd?
Yes, my lord. And in the meantime, my lord, I will get that textbook and
that will be so simple. That will fall on 22nd at the request of panel solicitor hearing for the commission.
Certificate of verification is posted to 17th, my lord.
Verification is 17th.
Verification certificate, my lord. They may fill up the post, my lord. You'll not see
one post you don't fill up.
Otherwise,
category, my lord.
He is within that particular selected category. He wants more 1 mark, my lord. It is his submission. Well, I cannot say anything more because I do not have any.
Let us see on that day.
On that.
I should mention one case which A.P. Herbert in Uncommon Law. A.P. Herbert was a very curious writer. Uncommon Law, leading cases, misleading cases are his books. More misleading cases, these are his books. He will very bitterly criticize the judges. And to ensure that no contempt proceedings are taken out, he will call judges for the books. Okay, in one book, in Uncommon Law, whether what happened, a whale came to be washed away to shore, seashore. People said to the Animal Husbandry Department, they give a Fisheries Department, they applied, saying that whale is decaying, therefore please remove it. Fisheries Department said that though whale resides in the sea, it is not a fish and therefore it does not come to our department. Therefore these people made an application. Animal Husbandry. Animal Husbandry people said, though whale is not a fish, but whatever is in the sea is treated as part of a Fisheries Department. It is like this only. You are referring to one, he is referring to another. Let us see. At least we can ask the expert. Yes, that will solve the point. All right. Because in the apex court said in that famous Mailarappa alias Chikkamelurappa, if academic questions arise, court can decide with the aid of expert advice. That's it. Yes. Next.
Item 42.
May I please proceed?
Yes.
It is another subsection, my lord. The FA was dismissed for default on 14/7/2023, my lord.
14/7/23.
My lord.
For non-prosecution.
Non-prosecution, my lord. But the registrar has pointed out that petitioner number 5 has not executed the Vocational, but in the meantime he died, my lord.
Petitioner number 5 is dead now.
My lord. He died in the meantime, my lord. And he died on marriage. So no need of substitution.
Bringing a lot. No monetary benefit involved in this matter.
But he is survived by his mother and younger brother. Mother and younger brother.
They are parties here.
They are also petitioner number 7 and 9.
Who died? Who died?
Petitioner number 8.
Petitioner 8 died. Died on?
That, my lord, that certificate is misplaced, my lord.
There is a petitioner number?
I have filed, my lord, the copy of
certificate you have filed, na?
Death certificate I have filed. It is misplaced, not in my file, my lord. I have already filed.
You have filed application seeking restoration of the FAO.
My lord.
That's all.
My lord.
Now, any delay is there?
No.
I do not understand prayers in the petition. I do not understand Qadri stalls. They are very, very different. I don't say weird. Now that application to be allowed for restoring the main matter, to give one good book to the library.
Yes.
Right. Any delay is there?
No delay, man.
No delay.
It has not been pointed out.
Dismissed on which day?
On 14/7/23, 2023.
FAO was dismissed by the coordinate bench while order dated 14/7/2023. First option. Application or petition? For restoration.
Petition for restoration.
A miscellaneous petition supported by an affidavit is filed seeking its restoration, offering a plausible explanation as to why it came to be explained. Plausible explanation for the absence on the eventful day. First time. Counsel for the petitioner admits there is an eminent case for restoration. And non-restoration would cause injustice to his next one. He also replies to the obvious objection as to the death of petitioner number 8, saying that the petitioner's mother and younger brother already are on record as other petitioners, and the question of bringing any LRs would not arise. I agree with this. Next time, in the above circumstances, the petition having been favored, FAO number?
FAO number, my lord, 192 of 2020
is restored to the board for treating on merits, for being treated on merits, subject to the condition that the petitioner shall present one book. Which book you will give to me?
Your lordship may suggest.
No, you people can suggest. Give one good book.
Yes, my lord. The book written by some God voice.
God voice. Okay. God voice and Supreme Court. Okay. Indian Supreme Court by Professor God voice to the Bar Association. Okay? Within 4 weeks. Within 4 weeks. Okay.
Item 43.
Item 46, there are 7 matters. But the only problem with that I have been appointed as amicus curiae by the Honorable Chief Justice in one important matter, and matter likely to be taken up just now. So, Your Lordship will permit me tomorrow at 2 o'clock. I'll argue the matter. I am ready with the.
I will tell the Chief Justice that I would not leave Mr. report. He has to be.
That Your Lordship. I'm sorry, my Lord.
Which date you want?
My Lord, tomorrow, I'm ready. Tomorrow, by any date, Your Lordship. Your Lordship fixes time.
Today is fixed for the last chance.
But the amicus curiae, the leader of the bar also.
On the important issue, my Lord.
We'll call this matter on 22nd.
22nd, my Lord.
Huh?
Yes.
Sir, all right. 22nd, all right, sir. After mortem.
My Lord, may please Lordship fix time.
Let it come, but it will and see pass over.
Yes, my Lord.
Otherwise, I will not dismiss.
Yes, my Lord. No, I'm not. My Lord, may interim order may continue till
continue this matter.
They are enjoying my last 2 to 3 years. They are enjoying.
I'm ready to
without complying with section 19 of the MSA.
Have there not been that team?
They have not deposited 75%. That is mandatory.
Interim order is continue. First one, the vehement contention of the net council. OP number?
Okay, sole OP.
Sole OP. That the petitioners are enjoying the interim order without complying statutory condition is noted.
Item 45.
Yes.
Sorry.
My Lord, 2 weeks time may be given to written statement. Counter list.
You want to file counter?
Yeah.
This is of 24th. More than a year has lapsed now.
I don't know what happened in this case.
Can we give a time?
1 week, because the termination matter, your Lordship may give me 1 week time.
All right.
And in this case, may I make another prayer matter?
Yeah.
Another read possession number 13991 of 2001. Maybe tagged with this matter.
With this, call this matter along with OJC.
1399 2001.
My Lord.
24. Yes. 24/10. It is open to the other side to file the counter if any time. Yeah.
Item 46.
My Lord, this is a matter, my Lord.
Yes, sir.
Related to grant of family pension to the deceased non-affiliated primary school teacher, family, my Lord.
Aided the school.
My Lord.
Yeah.
And my Lord, and his case is he was earlier approached before this rule court, my Lord.
Yeah.
And the order was passed, my Lord, and by at that time, my Lord.
Notice who appears for the other side.
I am there. My comment.
Mr. G. Well,
at that time, Lord, the rule is like favor.
I am for the accountant general.
At that time, my Lord, rule is my favor, my Lord. 1998 rule came into force, my Lord. And at that time, my Lord, it has clearly stipulated that the deceased died after. I approached before this rule court, my Lord.
1898.
1898, my Lord.
You are what? Widower, what is what?
My Lord, widow of a primary school teacher, my Lord.
When the teacher died?
My Lord, teacher died, my Lord. Died, my Lord, on 15/11/81, my Lord. I have given death chart. My Lord, I have prepared a death chart, my Lord. He entered into service on 7/3/1953, my Lord. And then, my Lord, actually, my Lord,
7/3/53.
53, my Lord. And as per the date of birth, my Lord, he would have retired from service on 30/11/1995, my Lord.
2/11/1935.
35, my Lord.
So before birth,
Lords, while he entered into his date of birth is
1135.
His date of birth is 2/11/1935, Lord.
He would have retired on 30th.
30/11/1995.
Yes.
But he died on 15/11/81, Lord. Right. Then at that time, Lord, triple benefit rule was there, Lord, 1966, Lord. Then, Lord, 81 rule came into force, Lord. Then thereafter, Lord, in 1989, Lord, the amendment rules, Lord, came into force. First time, family pension would be admissible. Because prior to that, there was no provision for a grant of family pension, Lord. And in 89 rules, the cut-off date was made, Lord, 1988. Because those family, those deceased died after 1988, they are entitled to get the benefit of their family.
On or before 1988.
On or before 1988.
Died 1988. They were entitled to family pension.
My Lord. And that cut-off date was challenged in Vincent Pusti case rule, my Lord. Rule 98 rules, my Lord. But what they done, they remain silent, my Lord.
No, read the direction.
My Lord. If in fact the petitioner's husband has rendered pensionable service, if it is found that he had rendered pensionable service, the opposing party shall pass necessary orders within 4 months of receipt of this order, granting family pension and TI on it to the petitioner, keeping in view the aforesaid rule 82 of 98 rules.
Sir, will produce necessary documents in support of her claim before. What is that cut? Very if.
And within 4 months, Lord. But after 2 years, Lord, my pension paper, Lord, was taken action, Lord. So by that time, 2001 rule came into force, Lord. And in 2001 rules, some restriction was there, Lord. Because again,
that is not applicable.
Not applicable. Again, 1988 cut-off date also imposed.
In that.
By virtue of that, my Lord, I have been deprived to get the benefit. So, and the Annexure 6, my Lord, page 32, the Accountant General, my Lord, intimated to the day schools, since the petition is not get the benefit in view of the notification, my Lord. Coming into force the 2001 rules, my Lord. So against that, my Lord, I approach before this Honorable Court, my Lord.
No, when you say something,
my Lord,
you should stop somewhere.
From this, my Lord, the actual fact came, my Lord. Okay. I approach before this Honorable Court, my Lord. And sorry.
You are not taught full stop, comma, semicolon in school at all.
My Lord.
If you make a statement, you should allow the listener to assess it.
Well,
where is the full stop in your this? Continuously it is going on.
Well.
So earlier under which rule court decided rule 8(2) of which rule? Come to your application. Always see.
My Lord.
1 second.
Answer 3.
1 second. Kindly look at me.
My Lord.
Kindly look at me. Kindly hear now. See, the best books on art of communication, like Gerald, they say, even Osho says, 2 monologues do not make a dialogue. You will say something, it's not a dialogue. When you make a statement, you should give reasonable pause so that the listener will process it. I am not that sharp, so I need little more time. Then depending upon how I am processing, how I am responding, the next sentence will be structured. This is fundamental art of communication.
Yes, my Lord.
All right, therefore, go little slow.
Annexure 3, my Lord, page 23, my Lord.
Annexure 3.
23.
Your whole case is that there is already an order of the High Court. The rights have become concrete there. In terms of that order, you should be given the benefit. Whatever amendment takes place is irrelevant. That is your case. Right. Correct? Or anything you want to add?
Another thing, Lord, this Honorable Court, my lord, in Subana Debe case, where the petitioner is one of the party, my lord.
In that,
Dispose of high judgment, my lord, 594, and the state, the opposite party, my lord, went on before the appeals court, and the same was dismissed, my lord.
what was the direction in that?
Direction, my lord, in giving certain observation and all decisions, my lord, this Honorable Court, my lord, has directed to take action and in the light of the aforesaid decisions mentioned above, my lord. And that matter, my lord, the state opposite parties, my lord, against that order, my lord.
And dismissed.
Then dismissed, my lord. That annexure of my lord.
Mr. G, what is the case?
My lord, so far as pension of the
Family pension. Case relates to family pension.
my lordship, your lordship is right.
Just I want to understand.
Yes.
The claim for family pension is founded on X rules.
Yes.
Based upon X rules, a judgment is rendered by a coordinate.
Two judgments are there.
Two judgments are there. Thereafter, Y rules have come. Question is whether his case should be governed by X rules because already there is a judgment.
Obliged.
Number one. Or it should be governed by the Y rules under which she will not be entitled to family pension.
My lord.
Now we have to show whether the Y rules are with retrospective effect.
My lord,
Enough to nullify
that is what I want to
judgment.
communicate to your lordship.
Yes.
Before that, my lord, my friend has submitted that, he has already submitted that so far as primary school teachers are concerned, there was no pension or pension rule earlier.
Correct.
For the first time in the year 1966, the triple benefit scheme introduced with effect from 1/4/1964.
1964.
64. With effect from 1964.
64, why 1966 rules?
Yes. Non-government. The name of that rule is, my lord, Orissa non-government provident fund, insurance, pension. These three benefits were extended to them, rules of 1966.
1966.
66.
So
But it will be effective.
triple benefit rules 1966.
66.
Triple benefit is benefits are one is
It is contributory provident fund,
CPF,
my lord, and pension. Three
CPF,
benefits.
and but here he died on which date?
He died, my lord, he has retired, he died on, he entered into service on 7/3/1953.
Correct.
My lord, thereafter, my lord, he died on 15/11/1908.
Died in harness.
Died in harness. My lord, so far as
So as on the date of death, 64 rules were 66 rules were in operation.
were in operation, my lord. My lord,
They provided for family pension also?
no,
Only pension.
only pension was there, contributory pension. Unless somebody contributed, you are not entitled for that.
The family pension rules came into force when?
My lord, thereafter, my lord, so far as aided institutions, 81 rule came into force.
1981 rules.
81 rules.
After death or before death? He died in 1981.
81.
15/11/81.
Yes.
Rules came into force when?
Rules came into force on 81, but with effect from 82. 1/4/82.
1482. So after death.
After death. My lord, the family pension so far as is concerned, my lord, there is another set of rule which came into force. Non-government fully added primary school teachers retirement benefit rules.
But they came into force when?
That rules I am not.
89, my lord. 89.
1989.
89. 86.
Whether they cover those cases where death occurred before that?
My lord, that covers that. It speaks, my lord, on 1988.
With effect from
1988, if on the persons died on or before 1988,
then he is covered.
Are entitled for that.
Correct.
So, your lordship, in case of Bhimsan Prusti's case, decided the matter.
Correct.
Thereafter, my lord, the amendment to 1 was introduced, which I have annexed that in my counter affidavit. In my counter, my lord.
Now, I want to just, I will go through.
Yes, you, my lord.
What is your stand, whether he is given, he should be given family pension or not?
Obviously, counter speaks no.
Why?
My lord.
But there is a judgment.
Yes, there is a judgment.
Yes.
Persons died on or 1988.
Not only that, judgment in her case only.
My lord, the family pension he is entitled to, provided the husband got pension.
No, we do not know all that. So how the rules read?
My lord, lordship.
How rules read?
My lord, lordship, I'm not with the rules now, my lord. Lordship, unless and until the husband gets pension, my lord.
Where is that the rule?
The wife cannot get family pension.
No, we do not know. Suppose it is for the policy, it's a pension in the policy pursuant to our directive principle.
My lord, lordship, I call this matter tomorrow. Tomorrow, I will come with all me.
I will also look into income.
Yes.
The decision which says, unless husband is given pension,
I'll get that.
wife cannot get, the widow cannot get the family pension.
I'll try to
I'm
get
very
that.
sure of. Anyway.
Tomorrow or day after tomorrow?
No, not possible. This week, not one. Call this back on 3rd of November. 6th of November.
My lord.
6th of November?
No.
November 6th.
Yes.
My lord, he said tomorrow, my lord.
No. Tomorrow I have to survive, na? There are many matters.
Among the
The of memos are moved.
My lord, this is 8 years, she is 8 years old, my lord. That now buried in this. My lord, earlier,
don't worry, perhaps the benches are not being changed. So, item 37.
Is for the
What is your say? At least you also look into and come back. Because there is already a judgment.
Two judgments are there. Two judgments.
Not only law. Judgment declaring law is one thing. Judgment already a judgment in our favor.
Yes. Yes.
That cannot be altered.
66 rule is the problem. 1966 rule.
He is not coming under.
Under the rule.
That he is not coming, but what he says is, he is covered under this latest rule.
He is another decree holder. In the 66 rule.
She is a decree holder.
No, in the 66 rule, he is not a decree holder. As per the 66 rule.
Let us.
Who is the decree holder? He is entitled.
Have you filed objection?
I have objection.
I look into that. Yes.
Yeah, item 47, my lords. I beg pardon on behalf of the conducting council, Mr. Ponda, he met accident, my lords, yesterday. For which I pray for some, because the earlier order also your lordship pass has not been complied also. That's why I prayed time.
I should not object what the ground is stated. Your lordship kindly see
that all order will have to be kept in suspended anyway. Person is has
only one. My lord, on last occasion passed for action of a self. Now the one council is
absent for his own cause. Let him remain absent, no problem. But by way of affidavit, let the shielded copy be filed.
Be filed, my lord. Because the encroachment has been made.
Let time be allowed.
8/9/2025.
Last order, my lord.
Alleged encroached portion.
The total road is encroached, my lord. That is, I am the old sufferer. I am not approaching my road. It's a half-constructed road, my lord. In two forums, they lost.
Petitioner to order dated 8/9/2025 and the next date of hearing call this matter on 13/11. Okay.
Out early, my lord. Very first week of the
Yes.
Item 48. 48, my friend Mr. Das has requested me to make a mention that he is on legs at Chief Justice Court. Let's may call this matter any day.
Call on 6/7. Yes.
Item 49.
Yes.
We have filed the counter, my lords. Here, my lords, the counter of the state is also necessary, my lord.
No, the counter of the state at best may be a proper party. The state's comment is already in its letter communicated to them. I don't think there is nothing to improve. The state has no objection if a relief is allowed. In fact, it is the state which has complained that you have sent a wrong recommendation, not in terms of the earlier judgment. Let me.
So you say that state need not weigh the objections.
No, your lordships, no, they are talking about the union, your lordships. And as far as the state government is concerned, your lordships, our case precisely is this decision.
Not of the foundational.
Yes, your lordship. That's exactly what we
already in the matter.
Yes, your lordships.
Yes.
So we have not filed.
May I just your lordship?
He's saying
Only because
silence government advocate that way. I don't like that.
I want to support him.
there was a
That's all right. But you are not supposed to silence the government advocate.
No, your lordship, I want to support him, your lordship.
Not wait for me. Call this for some other judge. You are not supposed to silence the government advocate.
I wanted to support him, your lordships.
What is this?
Their case, I didn't mean to offensively say that, your lordship. May I apologize, your lordships? No, your lordships, I did not mean to stop him, your lordships.
You will be setting the standard for the end.
No, your lordships, I did
set wrong people.
support him, your lordships.
You are not supposed to do that.
I did not mean to, your lordships.
No,
I actually wanted to support him, your lordships. Your lordships, may I apologize?
You apologize to him.
Yes, I'm really apologetic. I actually, your lordships, no, your lordships, I'm really apologetic to it, standing because the petitioner should have actually spoken before he spoke.
That's all right. But you are a standard for rest of the people.
Absolutely.
You say all this.
No, absolutely. I cannot I cannot but agree with your lordships. I cannot, your lordships. But I came under this misunderstanding. He's pointing out to the union because just outside the court only.
I've seen so many people. If government advocate wants to say threatening him, what you should do?
No, your lordships. Without their assistance, in fact, if a good government actually makes the petitioner work easy, your lordships. I'll never do that, your lordships.
Can we take this matter some other day?
May I just clarify one thing in regard to this counter, at least, your lordships? May I just clarify this?
Yes.
I mean, your lordships, actually the matter is against an organization called OPEPA, which looks at this education, your lordships, in the school and the primary education, your lordships.
Yes.
Now, your lordships, there's already a judgment in our favor. And all that the court said in that judgment is, you the recommendation, the favor of the petitioners to the union as well as the state government. They did not send a letter in terms of that judgment. And that's exactly been the letter of the union.
Yes.
That you should have sent it in terms of the court recommending for release or whatever it may be. They said, anyways, we have nothing to do with it. The state government has adequate powers to do. What OPEPA did not send a letter to the state government. And when did it send the letter to the state government? When we filed a contempt. And state government hasn't taken any adverse decision in our, as far as we are concerned. But they passed an order that we are rejecting your claim, even though even in the earlier judgment, the claim has been allowed.
Yes, sir, Mr.
I don't have any instruction. That is what I have pointed out.
2024 methods.
No, earlier litigation is.
If I may, my lord,
No, earlier litigation is of.
I'm appearing for OCP number 4, my lords. If a lordship may kindly see the direction, page 91, the earlier direction of the Honorable Court. There, a direction was prayer was to extend the benefits to them at par with the employees working at district and state level.
Correct. Before the central government. What is that you have done pursuant to this order? Because of your tug of war between you two, president should suffer.
We placed the demand before the central government. Central government intimated us that it is within the domain of the state.
You means who?
OP4 Malus. OCP Malus. OP4 Malus. In this
OP4. What is your status?
I am for the OCP Malus, Odisha State Education Program Authority, which functions under the School and Mass Education Department
of the government.
My lord, that is why I was requesting that government also needs to file counter, because we first placed the demand before the union government as per the direction. The central government intimated that it is completely within the domain of the state to look after the implementation of the program as well as other aspects, and the program as well as other aspects, and accordingly this we placed again the demand before the state government also, and state that my lord, we have also.
But para 8.2 say
my lord,
the 60-40 ratio.
My lord, that is the ratio in which the funds are being sanctioned. That is 60% by the central government and 40% by the state, my lords.
Correct. Yes, Dr. Behura.
So
My lord, your lordship.
Unless that fund is being sanctioned adequately, we are under.
The mistake is on part of the OPEPA. For simple reason.
They have not sent.
No, for two reasons. One is the recommendation which is sent to the state government now is not in consonance with this judgment. That's one aspect. Second, your lordships, they did not give adequate time to the state government before they could take a decision that rejected our claim. That rejection, yes, your lordship. So at least that order can go, irrespective if the state government has taken a decision. You did not even wait for the state government's decision.
When you had sent place material before.
Lordship may kindly see the impugn order.
Madam, I feel let me file a short statement so that it becomes ID. 3rd of November.
Lordships.
Kindly do not mistake, because
no, absolutely. No, you
there have many disadvantages, I tell you. I will not deliberate on that. With the officers will not cooperate.
I know.
And we fall on them. And the advocates on the petitioner side will fall on them. They have many disadvantages.
I absolutely agree, your lordships. A judge is not only a judge for us, he's a teacher also, your lordships.
Because otherwise, secondly, you should set better standards for rest of the people.
Your lordships, I'll accept. I wait for an opportunity to learn. And we learn from our mistakes, your lordships.
Timothy, the council opinion for me, OP number 3. 4. OP number 4. The invitation to come out with, to confer with his clients and file a short counter personally. To facilitate the same, call this matter on 3rd of November. Item 50? May I please? Yeah.
Lords, this matter relates to the release of fees, Lords, professional fees of a government advocate, my lords.
Professional fees of government advocate. Mr. Behura, you should be ready with your petitions.
My lord, it is very embarrassment.
What is this?
Still, stand is that they are not entitled to that.
They are not entitled to. Why?
Because, my lords, the additional government pleader is governed by GRCO. And only retainer fees is entitled to.
Only retainer fee. Retainer fee of how much?
Earlier it was, now it is 12,000 and
12,000 per month. 12,000. How he will survive?
And
12,000 plus per case, so much.
Yes,
That
yes, that is, PRCO prescribes certain percentage on the value, ad valorem,
on the fee of the case involved.
yes, value of the case.
Why he is not entitled to?
No, that is,
Except the retainership, nothing.
no, lords, here, my lords, daily fees is there. I will satisfy your lords.
Show that.
My lords, your lords may kindly take my rejoinder, my lords.
Agenda. Under which rules you are
Yes,
writing?
lords, lords, rejoinder page 12, my lords. The rule I have annexed to my rejoinder, lords, page 12, my lords, may kindly turn.
Page 12.
Yes, your lords. Page 12, my lords, first paragraph, my lords.
25.
Point number 6, my lords.
Point 6.
Lords, just above 25, rule 25. I will also place 25, my lords. The daily fees payable to the law officers, lords. Daily fees payable to the law officers appearing before the different revenue courts through the district level, in the district level, labor courts, debt recovery tribunal in the district shall be rupees 300 inside the headquarters and rupees 600 outside the headquarters. Now, lords, just below, lords, rule 25.
Yeah.
The daily fees in courts other than sessions courts shall ordinarily be reduced by half when government pleader, associate lawyer instructed by the government pleader. This is important. Lawyer instructed by the government pleader is occupied in a court for less than 3 hours per day. Now, lords, I have been instructed by the government pleader. Lords, that Annexure 2 your lords may kindly see. Initially, I was appointed, Annexure 1, lords, my appointment letter is Annexure 1, lords. Initially, I was appointed, lords,
As the additional government pleader.
additional government pleader in the Court of Civil Judge Senior Division.
1 second. Additional
Government pleader
government pleader.
in the Court of the Civil Judge Senior Division, Nimapur.
18/8/2012.
Yes, your lordship. Now, my lords, Annexure 2, your lordship, may kindly sit at page 13, my lords. 13, my lords. This, by virtue of this letter, lords, government pleader, my lords, clause, column number 2, government pleader, my lords, allotted me to appear before, because
Allotment of
lords, lords,
to the, what is that? Allotment, paragraph 5 and 6.
yes, allotment of courts to the AGP, Santosh Kumar Mahanti.
Additional government pleader, so and so, so and so.
Yes, your lords. By virtue of this letter, my lords, I have been instructed by the government pleader to appear before the lords of additional decisions court.
Go to that
Rule position, lords, rule.
You read that, na?
Yes, 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 your lords.
53 lords.
Lords.
Page number?
Page number 12. Rejoinder, page number 12, my lords.
Page 12.
Yes,
Of rejoinder.
yes, your lords.
Go to 12.
The daily fee in courts other than sessions courts shall ordinarily be reduced by half when the government pleader, associate lawyer instructed by the government pleader is occupied in a court less than 3 hours.
When the government pleader,
Yes.
see that, government pleader is one category. Associate lawyers, another category. Instructed by government pleader is at another category.
Yes, lords. Lords, I was instructed.
You are not a lawyer instructed by a government pleader, but you are a government pleader.
Additional government pleader, lords.
Government pleader is additional
yes, yes, yes,
under the rule
yes,
itself.
lords.
Therefore, this is not applicable to you. Lawyer instructed by government pleader means, suppose some private lawyer is instructed by government and government tells you to instruct him, brief him. Such cases are not covered, they are covered, not you. Because you are yourself the government pleader.
Yes.
You are not instructing anybody.
Lords, why I am submitting that, lords? Because initially I was appointed to appear before a particular court, lords.
Correct.
Now, by that time, additional decisions court was not there.
after establishment of the additional decisions court, my lords, I was instructed by the government pleader. Government pleader is
instructed. You are
no.
government pleader.
No, government pleader is, my lords, appearing in the at Puri, my lords. Headquarters is at Puri.
Were you government pleader or not? I will not say government pleader instructed by another government pleader. Kindly see the text of the rule.
This letter
does not say government pleader instructed by another government pleader. It uses the word. Kindly see the words are very. Lawyer instructed by government pleader.
Yes.
So private lawyer may be engaged by the government in important matters, as you know. Is it not? Private lawyers are engaged by the government also. Government pleader to instruct the lawyer, government pleader. How the definitions, any definitions are given? Do you have entire rules with you?
Entire rules have annexed.
Go to the definition class.
Further,
who is lawyer, who is associate lawyer, who is government pleader, and additional government pleader, which is the definition clause of the rule.
Government pleader means, my lords, page 5.
Page 5.
My lords.
Go to.
Pleader means a person.
Additional counter. No reply. Page number?
Page number 5 of my rejoinder, my lords.
Your additional counter. Additional
rejoinder. That rules, my lords.
Rules. Go to this one. Orissa Law Officers Rules 1971. Short title. Commencement.
Definitions, my lords.
States for definitions. In these rules, unless the context of the public prosecutor.
Government pleader means?
Government pleader means a person appointed by the state government as such. You are one. Associate lawyer means a person acting under the direction of the government pleader and public prosecutor. Special counsel means any advocate specially appointed as government pleader or public prosecutor in any case or for any specified class of cases. Junior counsel means advocate in so for the law officer. State defense counsel. Where is the lawyer?
Lawyer is no, my lords, it has not been defined in the act.
It is not defined, but the indication is there.
Yes.
Means any in a special
counsel.
Special counsel. If you instruct that special counsel, that special counsel is entitled to particular fee, not the instructing government pleader. You are manhandling the text of the rule itself by your interpretative.
Now, my lords, 42, my lords.
1 second.
Page 30.
The contention as to lawyer instructed by government pleader would give benefit in terms of Rule 25.
25 minutes.
Rule 25 of 1971 rules at Annexure 5 to the reply statement of the petitioner is difficult to countenance. Regard being had to the dictionary clause of the rule, which defines clause of the rules. Next point.
Well, associate lawyer is defined.
Therefore, we can take it as lawyer also. Lawyer means a member of the bar, private member, chosen by the government for conducting special cases. That way, for example, Mr. Justice Chandrachud, Y.V. Chandrachud, was chosen as a special prosecutor in the K.M. Nanavati versus State of Karnataka, Prem Ahuja murder case. Okay, Jet Malani was chosen to assist him as a special public counsel. Such cases, these are regular cases. You are not instructing any lawyer. You are not a lawyer at all. You are additional government pleader.
So my case, lords, my appointment was for a particular court, lords. Thereafter,
Lords, after establishment of the additional decisions court, Lords, I was additionally, Lords, allotted the work.
Correct.
Therefore,
But you continue to be additional government government pleader only.
Yes,
There
Lord.
is nothing in this.
Lords, then, Lords, Rule 32(7), Lords, I may place your Lordship.
32(7).
Yes, Your Lordship, page
Yeah,
13. 13. Page 13, my Lord. Last word, 2 lines above, my Lords. In the bottom, my Lords. Rule
Bill of law officers.
Yes, my Lords, bills of law officers. My Lords,
Bills of law.
what's the end, my Lords? 7, clause 7, my Lords. Bills in connection with the civil cases should submitted as soon as possible.
After the
Lords, after each case is decided. Bills in respect of daily fees. My Lords,
any month should be submitted in the next following month.
yes, Your Lords. So, my Lords, the state government has filed the counter, my Lords, denying that there is no procedure, no provision for daily fees.
No, for you people.
Yes.
For government pleader, additional government pleader, there is nothing like that. For others, it is there.
No, daily fees is there, my Lords. Daily fees
It is for whom?
Lords, for the additional government pleaders, even
Where
for
is
the
that?
Lords of
Where is that?
Lords, that Lords, Rule 40, Rule 24, I have shown to your Lordship.
24, we don't agree with your.
No, 24, my Lords, 24.
24.
The daily fees to the law officers. 24(6), my Lords, page 12.
24(6).
Yes.
What to tell?
The daily fees payable to the law officers.
1 second. 24(6).
Lords, page 12, my Lords. 4 lines from the top. Clause number 6, my Lords.
Daily fees payable to the law officers
Appearing
before different revenue courts in the district level, labor courts, debt recovery tribunal,
and other such various
forums.
Yes.
You are not in any forum or court.
I am in the additional decisions court, Lords. I used to appear.
Kindly see that.
Lords.
This has to be read with the rule of ejusdem generis. Ejusdem generis means, see what are they saying? Revenue courts.
Yes.
District, revenue courts of district level, labor courts, debt recovery tribunal, or such various forums. It excludes regular courts. There is a maxim called ejusdem generis. Means, see, the text, they do not use the word regular courts at all. Revenue courts are included, labor courts are included, debt recovery tribunals are included, such other forums, not civil courts at all. They contain that Rule 24 provides for claiming fees. 24(6) is difficult to agree with. First, the said sub-rule reads as under. First, it attracts the maxim ejusdem generis in the light of apex court decision in University of Madras versus Shantabai. First off, the genus indicates that the regular courts are excluded from the purview. First off, the species also do the same. The said species being revenue courts, labor courts, debt recovery tribunal, It is ejusdem generis because the expression used is other such various forums, which are like quasi-judicial bodies and not regular civil courts. Okay.
Lords, I want to, Lords, bring to your Lordship to page 2, para 4 of my rejoinder, my Lords.
Yes.
Lords, I have pointed out certain points, Lords. First of all, my appointment is not in dispute.
Correct.
Lords, secondly, so far as the entrustment of the work before the additional decisions is also not in dispute, my Lords.
Correct.
Now, Lords, I am also working before apart from the civil senior division, I am also, my Lords, conducting cases before the additional decisions court. That is also not in dispute.
Not in.
My Lords, I have also been paying, my Lords, they are paying me, my Lords, since from the date of my appointment in the ADJ court, my Lords, since 2017.
They were paying what?
Daily fees, my Lords. I have been paid, my lords. For a particular period, my lords, my bills are pending. They have not rejected till date, my lords.
No, but where is the entitlement?
Lords,
Entitled to only the retainership. What is that word used here? Retainership. Coupled with the fees also. What is that fee?
That fee is, my lords, our counter is 12. My lords, kindly first see page 10, rule. Page 10, rule 17. The fees payable to government
civil cases.
My lord.
The fees payable to government pleaders, additional government pleaders, and associate lawyers in state civil and cases tried under the CPC shall be ad valorem fee specified under the general rules and circular orders of the High Court of Orissa, Civil Volume 1, subject to a minimum of rupees 5.
Then, my lords, kindly go to.
That will not help you. General rules and circulars, which are those general rules?
I have annexed that.
That also.
Page 12, my lords.
Page 12.
Fees of advocate.
Fee of advocate. Scale of advocates. The following scale of advocates exceeding 10,000. That fee is paid. In addition to retainership, this fee is paid.
Yes.
Now, what he is claiming is more than that.
No, he is claiming daily fees.
Daily fees.
It is not there.
Apart from that, retainership and these.
Retainership and fee ad valorem basis, he wants daily fees also. Where is the provision for granting daily fees?
This is not applicable, lords, because this is, lords, 400 scale of advocate fee. This is a scale of pay, my lords. This is not the pay for the additional government advocate or the government pleaders, my lords.
No, next.
Scale of advocate's fee.
Yes. That is, my lords, the following scale of advocate's fees shall be ordinarily be allowed to the successful party.
Huh?
To the successful party, your lordship may kindly say.
That is adopted by virtue of that rule.
No, this is
adopted under that particular rule, which
17.
Rule 17. Kindly come to 17.
Yes. Fees in civil cases. The fees payable to government pleaders, and government pleaders, and associate lawyers. Page 10.
10. Yes, brother.
Lords,
Remuneration payable to law officers. Section 17. Fees in civil cases.
Lords,
the fees payable to government pleaders, additional government pleaders, and associate lawyers in contested civil suit and cases tried under the CPC shall be the ad valorem fee specified under the general rules and circular of Judicature Orissa, Civil Volume 1, subject to minimum 75 rupees.
Lords, that is, lords, that is applicable so far as my appointment is concerned. My lords, my case is that when I have been entrusted with the additional work, lords, I am claiming for my additional work, which was entrusted to me.
Where is the provision for additional work? You should be paid the fees.
So I have been paid, lords. They are paying me, lords, since from the date of my lords entrustment, lords, till date. For a particular period, lords.
If they have paid, you retain it. They have not sought for recovery.
Lords, because I have drawn the for which they have paid, lords. Lords, I am entitled in the lords rule for subject to your lordship's consideration.
Otherwise, I would have allowed it. If you saw something, I will allow the. Otherwise, I am against denying relief to any litigant, more particularly to the lawyers who have worked for the government.
Lords, I have claimed, my claim is there, lords. I have sought for the relief that I have worked for additional work for a particular court, my lords. I have been appointed for to work in a particular court. Since when I have been entrusted with the additional work, lords, I am entitled to get my fees, lords. That is my question.
Does not provide for that. You should have said, no, I don't go to other court at all. Because you are not going to pay anything. I will not go there. No plea can be given beyond what the rules prescribe.
That is, therefore, I have, so I am submitting rule 25, Lords. Since I have been entrusted by the government pleader, Lords, who is working before the headquarters, Lords, at Puri, Lords.
Petition is this following. Number one, the fee claimed by the petitioner is not supported by the ruled position.
Till date, Lords, it has not been, Lords, they have not, neither they have.
No, they have said no. By finding objections.
Only when I approach your Lordship, Lords, they in their counter saying that I am not entitled to, Lords.
You pay cost, Mr. Though we are dismissing the petition, he is made to fight the case. You pay 5,000 rupees cost.
Right.
Otherwise, they should have said, no, you are not entitled to. You would not have come to court at all. Since you did not take any decision on the...
My lords, there is a letter of government pleader himself that is not entitled to.
Government pleader's letter to whom?
To the department, Lord.
To the department, what is they should do? Well, that letter is not sent to him. Had you sent that letter to him, he would have thought and he would have consulted whichever good advocates available and taken a decision not to go to the court at all.
My lords, no, it's go.
Brother, dismissing this petition is a bit bad thing.
Lords,
give an option to me.
Lords,
because I will write that judgment is another thing.
Lords,
but that will be a judgment on record for rest of the time to come.
So, you Lords, you keep it to next week. I'll take instruction. Lords, I'll take instruction from you, Lords.
No. If you want to withdraw, otherwise, the order. But it will be part of the record for the history of the court throughout.
Lords, you keep it to next week, Lords.
What is the next?
I'll take some instruction from the people, Lords. Lords, the petitioner is 70 years old and working since 2012.
That makes even at 101.
Not difference, Lords, but he's working for the government, Lords, without any fees. That is the, Lords.
Refer to Rule 17 and the general rules in turn which have been adopted. Okay.
I think we pardon your lordship. Item 50.
So that is 2 weeks. And one your lordship wanted one judgment at the time of argument that is Karnataka judgment. I have got that. WPC brother, I am handing over to court master.
In other matter,
that regarding establishment of school and that is the liquors of wines. I have got it.
Give that. Can you pass on to that that old gentleman who was arguing well? Just
judgment is not available, but the petition number and subject matter is available. That judgment is not available in the book. That therefore I am providing that petition number and
you take
the summary also.
That and send that copy to that lawyer who sat here. Who argued was not well. Send that copy to him.
My item 56. Let me comment 27.
27.
An entry model there is by the petition company that has to come.
You are perfect.
I have no.
27 we have difficulty because we have posted many matters in the first week of November. Entry model to continue. I am
Item 51, can it come up tomorrow, my lord?
51?
51.
No, tomorrow very difficult, sir. We have loaded
we have a problem, my lord. The directors have been blacklisted without a show cause. That is why, my lord.
Company matter, no?
Yes, my lord.
And I rejected that.
No, your lordships have kept the directors matter. Your lordship said that your lordships will hear. So I pray that it come up any day next week, my lord.
Next week, sir, we have difficulty. We'll have it second week of November. Give that one date.
My lords, a date may be fixed.
Yes.
13 lordships Wednesday and Thursday will be in the Hon'Ble ethics code. 11th or 14th.
17th we have that.
11th?
17th only.
11th?
11th?
Yes, ma'am.
11th. All right, 11th.
Grateful.
56.